Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to the second day of our spring oral argument session here in Pittsburgh. It looks a little more like spring today than it did yesterday. As you may know, the Pennsylvania Supreme Court is the oldest Supreme Court in North America. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. We celebrated the court's 300th anniversary in Philadelphia in 2022, and we on the bench are very proud of our court's rich history. It's truly an honor to work and sit in these majestic courtrooms in Philadelphia, Harrisburg, and Pittsburgh. As you likely noticed entering our courtroom, our court has a tradition of hanging oil portraits of former Chief Justices in our courtroom spaces. Today, I'd just like to briefly mention a couple of the portraits here in our Pittsburgh courtroom, and I thank our court crier, Brian Minner, for taking an interest in our court's history and compiling these biographies. Our court actually now has its own historical commission led by Justice Sally Mundy. Starting with the portrait hanging to my immediate left, don't worry if you can't see him clearly, because he would not have been able to see you clearly either. He had severe vision issues. He had his portrait painted with his glasses on. Chief Justice Drew suffered from poor vision for most of his life. His doctors advised him to quit Columbia Law School because of the effect the reading of lengthy opinions had on his deteriorating eyesight. But he was undeterred, and he rose to the highest position in Pennsylvania courts. Likely because of his poor eyesight, Chief Justice Drew limited the length of his opinions and joked that the legislature should charge justices for the printing costs of any opinions over 3 pages. Might be a good rule. Mr. Minner, did I point to the wrong portrait? This is him. Okay. Next, he is the one with the glasses. Next is Chief Justice James Sterrett. He began his public service on the Allegheny County Common Pleas bench before his appointment to this court by Governor John Hartranft. Justice Sterrett lost the following election after his appointment, but ran again and won a seat on this bench. He became Chief Justice in 1893 and served until his retirement in 1900. To his left is Justice, to his right, I guess, is Justice Robert Fraser. Chief Justice Fraser served as an Allegheny County Court of Common Pleas judge before his election to our court in 1915. He became Chief Justice in 1930 and served until his retirement in 1936 at the age of 86. Don't worry, none of us are staying that long. With a legal career spanning 62 years, 40 of those serving as a judge. So just to highlight a few of the portraits on the wall. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent and introducing your co-counsel to the court, if any. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues, Please remember we do not allow rebuttal. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question, even though we may be interrupting you. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues we wish to explore further. While there is no time limit for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Ruth Ann Grant versus Louis A. Grant Jr., representing Ms. Grant, Mr. Justin Tuscan, representing Mr. Grant, Mr. Thomas Marshall.
In this appeal by allowance, we must determine whether a joint tenancy with the right of survivorship may be severed by one party to the joint tenancy by unilaterally conveying her share of the subject property from herself as grantor to herself as grantee, with the stated intention of severing the joint tenancy and creating a tenancy in common. Please proceed.
Good morning, Madam Chief Justice, Justices. Justin Tuscan on behalf of Ruth Ann Grant as executrix of the estate of Ruth Grant. The issues before the court today, as the Chief Justice just noted, can largely be distilled into one question, and that is, did the conveyance of the subject property by Ruth Grant to herself prior to her passing via quitclaim deed sever her joint tenancy with right of survivorship with Louis Grant? The appellant submits that the court's answer to this question should be yes for the following reasons. First, the quitclaim deed was a sufficient manifestation of Mrs. Grant's intent to sever the joint tenancy from which she could not retreat. Once the predominant form of ownership at common law, joint tenancies are now disfavored in this Commonwealth, and they can be unilaterally severed. Our courts have said that severance and the act that manifests this severance has two requirements. There has to be the manifestation of the intent to sever, and there has to be an inability to retreat from this severance. There's little question regarding Mrs. Grant's intentions here because that intent is stated in the plain language of the subject quitclaim deed. And it's long been the law of this Commonwealth that when language in a deed is clear and free from ambiguity, the intent of the parties is to be determined on the face of the deed. So we look to the face of the deed, and what does it say? It says that the purpose was to sever the joint tenancy between Ruth M. Grant and Louis Grant, and to thereby and thereafter create a tenancy in common between them.
Counsel, can I ask you a law school question?
Yes, Mr. Justice.
I always understood quitclaim deeds as basically saying, I am giving you what I have, and that's all I'm giving you. I mean, it's no more, no less. It's what makes the quitclaim deed is it is what I have. Can you execute a quitclaim deed that gives you more or different? And which controls the nature of a quitclaim deed itself or what you put in the contents of it?
A quitclaim deed, by definition, as Your Honor noted, conveys what you have. There are no warranties with respect to title or the like, which is juxtaposed with a general warranty deed, which says, I warrant that I have good and marketable title to this real estate, and I'm going to convey that good and marketable title to you. A quitclaim deed doesn't have that type of warranty associated with it. But whether it's a general warranty deed or a quitclaim deed, there's no law in this Commonwealth that prevents a party from adding different or additional language to the instrument that, in this particular case, was stating the intent of what the parties were. So it wasn't as though Mrs. Grant was attempting to convey any more than she had, or that she was representing or warranting any issues with respect to the marketability of title. The instrument of conveyance here was a quitclaim, because she was simply stating, I'm giving what I had, and in this particular instance, I'm using this instrument to sever the joint tenancy that had previously existed.
You don't think that that's more than what she had?
I do not.
Why is that? I mean, what she had was a joint tenancy with right of survivorship interest. That's not what she pretended to convey by the quitclaim deed.
So I would answer that as follows, Your Honor. First, again, juxtaposing the different types of deeds, I do not believe that the question here is whether or not she was seeking to convey more than she had. I think the question is, if you are conveying an interest in property through a quitclaim deed, you are not warranting anything with respect to the title that you hold. But I don't believe that's mutually exclusive to being able to set forth in a deed a statement or other term or condition, as this deed did, that says there is to be a severance of the joint tenancy. Ultimately, there needs to be an instrument of conveyance to manifest intent. And I would submit to this court that whether or not it's a general warranty deed or a quitclaim deed is not the controlling factor. The controlling factor is whether or not the instrument of conveyance manifests the intent, and then the extent to which there's this inability to retreat that was a significant portion of the Superior Court's analysis. Because the Superior Court said that because Mrs. Grant didn't convey the subject real estate to a third party, she continued to have some type of control over the real estate and the overall parameters of the transaction, and that militates against severance because there could be a retreat. We submit to this court that that's not a correct analysis of the concept of retreat. If we look to other cases like the Annapolis decision, which is cited in our briefs, that stands for the proposition that the instant a party executes executes an instrument of conveyance, that then manifests and creates the change in title. In that particular case, it was an agreement of sale. And the agreement of sale had been signed, and then equitable title was transferred to the buyer. In the context of a deed, which is what we have here, the deed is signed, delivered, it's recorded. Title to the property has now changed.
But it hasn't. It hasn't, because she still has title to the property.
She now has title to the property as a tenant in common, not as joint tenancies with the right of survivorship.
I guess the question is why? Why? And I understand what you're saying is, your answer to my question is, you can by quitclaim deed change the nature of the title that you're conveying. I see how that works with retreat if, as a matter of law, you convey a interest to a third party, but I'm struggling with how she could improve her lot as an owner of this property by simply a quitclaim deed. Because she's still, the owners are the same.
Mrs. Grant has always held an interest in property from the very first conveyance, as the record shows, to her, then to her and Lewis Grant, and then through the quitclaim deed. What that did was change the nature of the holding from a joint tenancy to a tenancy in common. And
Did she change it back?
could she change what back, Your Honor? I apologize.
You went from a joint tenancy to a tenancy in common by a quitclaim deed, so she could change the nature of her title in the property, right, through quitclaim deed.
Correct.
Okay.
Yes.
Could she change it back if she would have survived?
She could have, yes.
So doesn't that defeat the retreat argument?
I do not believe it does, Your Honor, respectfully.
When you have a third party involved, you'd have to get the third party to agree to give you the property back. That seems to be where retreat falls in. But if she always had the option of, she could have, under your theory, she could have executed a quitclaim deed every day.
I think that the hypothetical that Your Honor poses goes to the larger question here of what is retreat in the context of severance of a joint tenancy. And the Superior Court says, if you maintain control, if you're the same party on both sides of the transaction, then necessarily you always have the ability to retreat. The problem with that framework is that it is belied by the same types of strawman transactions that the Superior Court would indicate or would hold were sufficient to allow for the severance of a joint tenancy. If you consider one of the examples of termination that's set forth in a case that we cite in the brief, it's the California Appellate Court case, Riddle v. Harmon. And in that case, you have an individual, her name's Mrs. Burke, and she writes a letter to her attorney, and her attorney said, and in that letter she says, I want you to prepare a power of attorney, I'm going to name you attorney in fact, and I'm going to do that so that we could terminate this joint tenancy that I have. And then her attorney, under this POA, executes and delivers a quitclaim deed conveying Mrs. Burke's interest in the property to a third party who's an office associate who works with this client and works with this attorney. And then this office associate, she comes along and she executes and delivers the quitclaim deed back, reconveying the interest. The individual at issue in that example that the California Appellate Court talked about maintained control of the entire transaction. It was a fiction that she wasn't involved, that she wasn't standing on both sides as grantor or grantee.
Yeah, but that's a different jurisdiction. There's many jurisdictions that do away with the straw man requirement. Pennsylvania is not one of them. In Pennsylvania, we have a specific requirement that requires an individual who actually makes the quitclaim deed an inability to transfer back. And in your scenario, why couldn't we just take a look at the complaint? She filed a complaint for partition. She verified a complaint saying she was seeking to transfer it out. If she had died without the quitclaim deed, could we accept that as manifestation of intent?
So I would respond to that in two ways, Your Honor. First, we are not arguing, nor is the issue before the court, as to whether or not the partition was the sufficient manifestation of intent.
No, but you're arguing the quitclaim deed itself is a manifestation of her intent to do so.
That's correct, Your Honor.
So why couldn't the partition action substitute itself for the actual quitclaim deed?
The difference between a partition action and what we're dealing with here goes to the manner and the timing within which title to property changes. In a partition action, there's no change with respect to the manner in which property is held until the end of the partition action. When an order of court or a judgment is entered and the court says this property is now partitioned, it's now divided, it's going to be owned differently than it was before the case began. That is much different than what we have before the court, where you're signing an instrument.
Why is it different, though?
It's different.
You're arguing manifestation of intent. She files a complaint in partition saying this is my intention, all right? But she always has an inability or an ability during the course of pendency of that action up until the point that the court enters its order to retreat from the action by filing a petition to null pros the case or settle, discontinue, and end. So if we treat your scenario the same way we treat a complaint for partition, she always has an inability to retreat, or an inability to retreat. I keep saying inability, excuse me.
I would agree with Your Honor that a partition action can manifest intent, but as to the second element, this court has held that because of the ability of a party during the pendency of a partition action to settle and discontinue it, that there is the ability there to retreat. What I am suggesting on behalf of the appellant is that when you sign an instrument of conveyance, that is the moment within which the title changes. And so we're not talking about a situation where there's 6 or 9 or months or a year's worth of litigation, and during that period of time a change can be made.
You would have us focus on retreat being something you can do before the title conveys.
That's exactly.
Not something that can be done after the title conveys.
That is correct, Your Honor. The case law in Pennsylvania has never, in my view, adequately defined what retreat is. So much of the prior jurisprudence with respect to retreat deals with the issue of a partition action. I would suggest to this court that the rule that Justice Brobson just articulated is the rule that should be adopted, which is retreat is what takes place prior to the execution and the transfer of title. That's why in these other cases where we've seen in Yiannopoulos, you sign an agreement of sale, title changes. General Credit Company, you sign a mortgage, title changes. I'd also like to address...
But that works only so far because really retreat becomes a synonym for control. And you're asking us to adopt this idea that all of a sudden, if I self-convey, I can't retreat. But the reality of it is, the actual reality of those circumstances is, maybe we have to say, well, true, when in the partition action, retreat is in the context prior to a decision. But if you're doing a self-conveyance, you can retreat after the fact. You could self-convey and self-convey and self-convey, and under your theory, alter the nature of the interest by a quitclaim deed. Why, if we're going to say that you can do a self-conveyance, why would you say we can't then change the definition of retreat?
In the hypothetical that Your Honor just mentioned, the subsequent conveyances are new conveyances. The concept of retreat, again, I submit, goes to one conveyance at a time. So if there is an instance where title to the property is going to change, and if you're in a partition action...
I apologize. I completely understand how retreat works in the context of the filing of a partition action, and how retreat works in the context of a transfer to a third party. What I'm saying is, you're asking us to adopt a new principle of law in Pennsylvania that allows this sort of self-conveyance, quitclaim legal fiction. And my question is, if we adopt that, why can't we also at the same time adopt a new definition of retreat that would go along with that type of self-conveyance?
I think that the court has the discretion to do that. I would respectfully disagree with one point that Your Honor raised, as well as Justice McCaffrey, and that is that self-conveyance in Pennsylvania is not a new concept. In fact, this court a few years ago, in an opinion that was authored by Justice Wecht, Estate of Plants, said that an individual is legally capable of effectuating a valid conveyance as both grantor and grantee. That case reaffirmed another decision by this court, Lafayette, which is around 75 years old. That was the first case in which this court held that a grantor could create a joint tenancy with himself and another through a single deed without a straw man. So I would respectfully submit, Justice McCaffrey, that...
Those cases deal with creation of a joint tenancy, not destruction of a joint tenancy.
That's correct.
Right.
But I would still submit, Your Honor, that Pennsylvania is not a straw man jurisdiction. that the jurisprudence of this Commonwealth has indicated in the past that self-conveyances, unilateral self-conveyances, are a valid and effectual way within which to transfer property. And if there's any lingering doubt on that point vis-a-vis the severance of a joint tenancy, then this is the opportunity for the court to clarify.
So, counsel, let me stop you real quick, because up until this point, we've been dealing with these kind of academic exercises, kind of philosophical constructs. I'm going to ask you a practical application, because this is something, as someone who's litigated these types of cases, comes across my mind. Your client files a complaint in partition that she verifies seeking to destroy the joint tenancy, correct?
That's correct.
All right. Then she actually does the quitclaim deed in this particular case, and the defendant in this particular case, her son, defended by saying, wait a minute, she procured her interest in the joint tenancy through fraud, accident, or mistake, right?
That was an allegation that was made
That's
in
how
the
he
lower
defended.
court.
I'm not saying it's true, I'm just saying it's an allegation. She dies during the pendency of this action. If we accept what you're saying in this particular case, how does the son defend now? Because under the dead man's rule, he can't offer any testimony adverse to her estate. So how does the son defend the partition action?
The partition action abated, Your Honor, and the partition action.
How does the son, who says she doesn't have any interest, the quitclaim deed, as you've already answered to Justice Brofson, indicates I'm giving my interest, whatever interest I have, to myself, and that therefore it flows to my estate. This is why we have partition actions. The partition action that your client filed is going to be abated. How does the son defend against that under the dead man's rule in Pennsylvania? Because the dead man's rule precludes somebody from testifying adversely to the estate of the person, right?
I would submit, Your Honor, that if this court reverses the determination of the Superior Court and...
Say we find there's a manifestation of intent.
Yes.
Therefore, her interest flows to her estate. How does Lewis defend against this particular claim? Or how does he get back the interest that he believes he has? Because he said early on in litigation, she doesn't have any interest. She procured her interest through fraud, accident, or mistake. How does he then claw back his 50% interest in the property that he lives in?
He will continue, if this court reverses the determination of the Superior Court, he will own 50% of the property.
But he says he owns 100%.
He made that allegation before the trial court below. It was an allegation that was not litigated. There was no discovery taken.
It wasn't litigated discovery because she died. Your client passed away.
That's correct.
So again, how does he retain his 50% interest in the property that he says your client procured through fraud, accident, or mistake?
Well, I don't believe, Your Honor, that he loses his 50% interest in the property. He still has that.
He loses the other 50% that now goes to your client's estate.
I don't believe that he had a 100% interest in the property.
You're not answering my question. You don't believe that, but I'm sure he's going to answer the question differently.
I would imagine that he would, Your Honor. And in the context of this particular case, and the question that the court is asking is what happens if it's remanded? I mean, there's going to be more litigation. I don't think there's any question. The parties are going to have to figure out what to do. Is one party going to buy the other party out? Is one of the parties going to say, I don't need to have a buyout because of fraud or whatever else? I cannot stand here before the court this morning and predict how that exactly will play out after remand. I think that, and I appreciate the question that may exist as to whether or not that is fair. But I would say two things under that particular issue. Number one, there are ways that parties can ensure that their interest in property isn't terminated unilaterally. You could have a joint life estate with a contingent remainder to the survivor. There could be a tenancy in common with an executory interest to the survivor. The joint tenants could agree to language in a deed or something else.
We don't need a discourse on property law. I had a very specific question. How would the defendant, her son, defend the case.
Yeah, and I respectfully, Your Honor, I don't know how the defense would take place below with the lower court. I mean, he can put on whatever evidence that he perceives there to be a fraud. He's allowed to testify to his own firsthand knowledge if or instances. He's allowed to call witnesses who may have been involved in whatever this alleged fraud was, and he would make his burden out that way. I ultimately do not believe that has a direct impact on the issues before the court today, because irrespective of how the case will be litigated or how things will continue, if the Superior Court is overturned and the case is remanded, the fundamental question that we're still dealing with is, was this quitclaim deed an effective way to sever the joint tenancy in the first instance?
Now,
And
can I get back to the first issue that we talked about? The quitclaim deed can only convey the interest that she owned. The interest that she owned was as a joint tenant with rights of survivorship. How does she transfer anything other than that to herself by quitclaim deed? I mean, you know, the whole concept that you're talking about, I think, revolves around one of the four unities, the termination of the title temporality. But with a quitclaim deed, she's essentially transferring to herself what she has, which is the joint tenancy by right of survivorship. There's no severance of the temporality of title in that context.
respectfully, Your Honor, I disagree that there was no severance.
Well, just how does she transfer something she doesn't have, which would have to be, in this context, the rights of a co-tenant? Because that's what she purported to be at the end of the transfer by quitclaim deed. That's not what she had prior to the quitclaim deed. I mean, I don't, you know, this issue of severance I think is interesting, but I'm and maybe these two things go hand in hand in the context of joint tenancies with right of survivorship. There's no divestiture of an interest, because all that you're transferring is the same interest that you ever held, which was a interest of a joint tenant with right of survivorship.
The quitclaim deed transfers the ownership interest without representation or warranty with regard to the state of title. And whether the purpose of this quitclaim deed was to transfer to a third party or if it was a self-conveyance, the quitclaim deed is still making that transfer without the representation or warranty regarding the marketability of title.
But when you transfer to a third party, you're breaking one of the four unities. Title is no longer held by the other person who was the joint tenant with right of survivorship. That's what happens when you transfer to a third party. You no longer have one of the four unities. That's not what happens when you transfer by quitclaim deed to yourself, because you can only transfer what you have.
This goes to one of the arguments that we make on the briefs, that so many of the analytical framework under which the issues of joint tenancies and severance have been considered before rely very heavily on looking almost exclusively at the four unities rather than the intent of the parties.
That's the law in Pennsylvania. I mean, we have a deep history of property law in this Commonwealth, and that is the law as it pertains to joint tenants with right of survivorship. You're not asking us to change that, or are you?
I would say two things in response. I don't think that it's necessary to entirely abandon the framework that exists. If the court is going to look at the four unities, we can say that the unity of interest and possession was destroyed because Mr. Grant and Mrs. Grant no longer had equal rights to the whole property as joint tenants with the right of survivorship.
But that's only if the title transfer was effective.
Correct.
You have to hang your hat on the fact that what the quitclaim deed did was sever the unity of title. The other things might fall by the wayside, but I mean, that has to be your starting point. That was, as you say, what her intention was when she executed the quitclaim deed.
That's correct. And I am hanging my hat on that. And if the court makes a contrary determination, then there was no severance. And we acknowledge that fact, that for the framework that we are advocating for requires the first determination to be that the quitclaim deed was a valid mechanism by which to change title. I would also, in the second part of my response there, just note that while the law of this Commonwealth has focused on the four unities, and there is certainly a robust history of common law real estate issues, the fact that something was one way before does not mean that it needs to continue to be that way when we look at sort of the historical big picture. Why were unilateral self-conveyances disallowed? It was because of the old feudal livery of season ritual where in order for title to property to change, you had to pick up a twig and hand it to the other person or a clump of dirt and give it to them. But we're centuries beyond that. Closings are now done through title insurance companies, and deeds and what have you are docu-signed with people sitting behind their computers. So these ancient feudal requirements that were the underpinning of some of that decisional law doesn't necessarily hold as much weight, I would submit, where we are now, when, particularly when there's already case law in the Commonwealth from this court that has started to step away or has stepped away from the idea that straw man transactions are necessary and an appropriate manner in which to convey title or sever what exists with respect to a joint tenancy.
I don't think the court has ever ruled that a quitclaim deed that changes to a self-conveyed quitclaim deed is a way to sever title. I think that's why we're here.
That's why we're here. Yes, Your Honor.
But you seem to be arguing, though, that we should abandon our history of requiring this legal fiction of a third-party conveyance for a new legal fiction of a self-conveyance.
I would submit, Your Honor, that what we're arguing today can fit within the current framework based on the decisional law that exists. But to the extent that the justices disagree with that, then yes, we can move beyond the legal fiction of the straw man. And that's one of the reasons why we cite to the cases from other jurisdictions. We understand certainly that that's persuasive authority and not binding on this court. But if you look at what the modern trend is by comparison to other jurisdictions, you find that the analytical framework under which joint tenancies are viewed, whether it's the creation or the severance of joint tenancies, focuses not as much on the four unities, but what was the intent of the parties. And if there was somebody who was trying to sever a joint tenancy, why we're not giving effect to that intent. At the end of the day, when we consider the deed that we have here, it expressly told us what the intent of the parties was, or what the intent of Mrs. Grant was. And if you're not honoring that intent, then you're making that particular part of the deed ineffectual. And
But counsel, you're also asking us to overlook what the definition of a quitclaim deed is.
Again, Your Honor, and I don't mean to belabor the point, but what the quitclaim deed is doing in any quitclaim transaction, it's saying, here, the interest that I have in this property, it's being transferred, and I'm not giving you any representation or warranty. I'm not going to defend you if there's not marketable title. If there's a lien on the property, so be it.
But she's saying, I'm conveying to me the only thing that I have, which is a joint tenancy with right of survivorship. I mean, again, you get a third party involved, you get the severance of one of those unities. When she's conveying to herself in this context, she's doing essentially nothing. She's giving herself what she has.
Our position is that a quitclaim deed, irrespective of the issues of intent and retreat, that a quitclaim deed can transfer property such that it was held as joint tenants with the right of survivorship, and then it can terminate that and sever.
I agree entirely. If the transfer is to a third party, it terminates the unity of title. And that's the end of the joint tenancy with right of survivorship.
If a party can create a joint tenancy by unilateral self-conveyance, then we respectfully submit that a party should be able to sever the joint tenancy by the same unilateral
The only
self-conveyance.
difference is when you're creating it, you're involving a third party. You're conveying to yourself and someone else. I mean, those situations are not what we're dealing with here. We're dealing with a situation where you have your decedent dealing with herself. When she created this with her son, you're right, she used a quitclaim deed to create the joint tenancy with right of survivorship. That's because she also conveyed to her son.
Correct, Your Honor, but I disagree with the statement regarding the third party insofar as when this property was originally conveyed to Mrs. Grant, and then it was subsequently conveyed by Mrs. Grant to herself and Mr. Grant. Mr. Grant wasn't a third party per se. He was the party with
Another party.
right.
She involved another party in the new deed because she was creating a joint tenancy. Obviously, she'd need someone else on that deed. But that's just not what we have here. I mean, this is really your decedent dealing with herself.
By the there was no third party. I mean, there was no straw man. We acknowledge that. We agree that we're simply saying that there should not be that requirement.
And I understand your argument. You think it's antiquated. You think the concept is antiquated.
Yes, the concept based on the historical view of the world, so to speak, of real property law and why some of these ancient rituals existed, they don't have the same place in our current jurisprudence. Fidelity to a historical practice, I would submit, is not by itself a justification for an ongoing legal rule. And I go back to what I said a few minutes before. If an individual can grant property to herself and another as joint tenants, then the inverse ought to be true. The same party should be able to sever the joint tenancy by conveying that estate. There's a quote in the Riddle decision from California from Justice Oliver Wendell Holmes, who said that it's revolting to have no better reason for a rule of law than it was laid down in the time of Henry IV, and it's still more revolting if the grounds upon which it was laid down have vanished long since, and the rule persists from imitation of the past. Now, I think revolting is far too strong of a term, but I do think the sentiment is correct when we look at the modern course of real estate transactions in this Commonwealth, as well as nationwide. The idea that we have to have a straw man in order to sever a joint tenancy makes it more cumbersome, it makes it more expensive, it adds complications to an otherwise relatively straightforward transfer, and it doesn't ultimately address the issue that the Superior Court seemed to be so concerned with, which was this idea of control. Because again, any party to the joint tenancy before the straw man transaction would necessarily have that same level of control.
Okay, Mr. Tuscan, we understand your argument, very well stated, and we're going to hear from Mr. Marshall. Thank you.
Thank you, Chief Justice.
You disagree.
I do disagree. May it please the court, my name is Tom Marshall and I represent Louis A. Grant Jr. I appreciate the spirited debate on the issue. The law in Pennsylvania is clear. The four unities do exist. The case law that exists clearly controls in this case. I'll start with citations to other jurisdictions. There are only a handful of other jurisdictions that have weighed in on the issue at all. As this court knows, they're only persuasive if there's not incompatible law in the Commonwealth. And there is incompatible law in the Commonwealth. We have Commonwealth decisions that make it very clear that in the context of real estate, the act must be sufficient manifestation of an intent to sever the joint tenancy with right of survivorship, that the actor is unable to retreat from the position of creating a severance. Those other jurisdictions don't have the concept of retreat. So I would argue they're not controlling.
Can I stop you right there?
Yes.
You said control of creating the severance. Your opposing counsel argues that once the title transfers, that whole issue of severance is moot. That the case law that we have in Pennsylvania regarding retreat is pre-transfer.
I agree with Justice Brobson that the grantor could issue a quitclaim deed, as was done here, to themselves, and then turn around and execute a new deed, and could be constantly changing the estate. I'd also submit that, let's say a quitclaim deed or deed of any kind is executed by a joint tenant from themselves to themselves. They could not record that deed and just wait. And if the other tenant predeceases them, they could destroy the deed. That's a retreat as well. So when the court says creating a severance, it's semantics, if you will, that we have the creation of a joint tenancy with right of survivorship, and then we have the severance of a joint tenancy with right of survivorship. And the case law speaks to what is effective to sever. And in this case, as in other cases, there was no divestiture by the grantor. In this case, Mrs. Grant did not divest herself of any interest. I appreciate the court's discussion about the quitclaim deed, because she can only convey that which she has, which is an undivided interest in the whole. She never divested herself. The cases which exist, which allow voluntary or involuntary severance of a joint tenancy with right of survivorship, invariably involve a divestiture. someone else acquiring an equitable interest, a purchaser with an agreement of sale, as in the Yiannopoulos case, a mortgage holder, a third party to whom property is conveyed. So there were many ways that it could have been accomplished. The way that it was chosen is not sufficient under Pennsylvania law to sever a joint tenancy.
Pennsylvania law is old.
Pennsylvania law.
It's antiquated. It's what I didn't hear from your opposing counsel is that it's unworkable, that it's unmanageable, that it's created problems, other than it's not convenient. But maybe why shouldn't we update our law for modern times?
Your Honor, I would submit that by changing Pennsylvania law in the manner in which appellant is seeking, this court is creating chaos where none exists. For instance, in 1812, our Commonwealth did away with the restriction on self-creating a joint tenancy with right of survivorship for the reasons expressed by appellant, the feudal law, livery of season. At the same time the legislature did that, they didn't see fit to enact any legislation addressing severance. The four unities of title controlled that, and in some other states they have passed legislation with controls and on the timing and notice and recordation and how soon in relationship to death. Other things that have been noted are that in certain circumstances, if a self-severance is permitted, the result can be patently unjust, where the joint tenant with right of survivorship detrimentally affected has put forward consideration for the position, or they've reasonably relied on that joint tenancy with right of survivorship. In this case, Mr. Grant, per the Superior Court's record and opinion and the record below, clearly put forth consideration for the initial purchase of the property, and then in reliance on the joint tenancy with right of survivorship, invested heavily in improving that property, and that's in the Superior Court record. So the problem with allowing, for the first time, a self-severance of a joint tenancy with right of survivorship is it would create tremendous uncertainty in a state. It would not require a divestiture. It would look beyond the four unities of title to some new concept of intent. And in this case, when I say a new concept of intent, the intent is important for joint tenancy with right of survivorship in the creation. We know that in the absence of some expression of intent, it's considered tenants in common. However, to take that further and now say that I can simply express an intent to sever does not comport with Pennsylvania law on the issue at all, and our position has always been that that deed from herself to herself is invalid and did not effectively sever. And
the legislature has acted in this area of joint tenancies with right of survivorship, correct?
yes, Your Honor.
With bank accounts.
Excuse me?
With bank accounts.
That's right. In the bank.
They could do the same here. They could do the same here.
Absolutely, Your Honor. And in the bank account cases, that's interesting because in those cases, where there's bad faith, they didn't want the party who engaged in bad faith to benefit from that bad faith. So that line of cases I would submit is interesting, but not controlling here.
Well, your argument's pretty straightforward. Are there any questions for Mr. Marshall? All right, thank you so much. Thank you both.
Thank you, Your Honors.
Call the next case, Mr. Minner.
Punxsutawney Hunting Club versus Pennsylvania Game Commission. Representing Punxsutawney Hunting Club, Mr. Joshua Wyndham. Representing the commission, Mr. Anthony Kolachek.
In this case, two private hunting clubs raise a constitutional challenge to various provisions of the Pennsylvania Game and Wildlife Code which allow game commission officers to access their property. In this appeal, we'll consider whether a game warden may enter private posted open fields without consent, probable cause, or a warrant under Article 1, Section 8 of the Pennsylvania Constitution, and whether our court's 2007 decision in Commonwealth versus Russo answering this question in the affirmative was wrongly decided. Please proceed.
Good morning, Madam Chief Justice, Associate Justices, and may it please the court. My name is Josh Wyndham. I represent the appellants, Punxsutawney Hunting Club and Pitch Pine Hunting Club in this case. With me today are Daniel Nelson and John DeSantis, my co-counsel, and behind me are several members of the Punxsutawney and Pitch Pine Hunting Clubs. Your Honors, the clubs are private places where members go to enjoy nature without being watched, to have private conversations without being listened to hunt without worrying that strangers might be hiding in the bushes. But 3 statutes have destroyed that privacy. They allow game wardens to enter and roam around nearly all private land in Pennsylvania without warrants, without cause, and without constraint. That violates Article 1, Section 8 of the Pennsylvania Constitution. The whole point of Section 8 was to protect privacy, including private property, from unfettered searches. And that's exactly what we have here. The Commission only has 3 ways to justify its power: Russo's open fields doctrine, stare decisis, or an exception to the warrant requirement. None of them work, and I want to briefly address the last one first. The Commission hasn't raised any exception to the warrant requirement, not for any of the 22 warrantless entries of my client's properties that we know of, not for the installation of a surveillance camera on the properties that took hundreds of photos. And even if they had invoked an exception, there is no exception to the warrant requirement that would authorize unfettered discretion to search property. And that's what we have here. The Commission conceded in deposition at 433A of the record that there are, quote, 0 limits on game wardens' discretion to enter private land. And so this case turns entirely on Russo and stare decisis. And I want to start with Russo. None of the Edmunds factors support Russo or the open fields doctrine, not text, history, state cases, or local policy. Starting with the text, the Supreme Court at the federal level, its entire justification for the open fields doctrine has always been, from Hester to Jones, that land is not listed in the plain text of the Fourth Amendment. Section 8 doesn't have that problem. It lists possessions, and land is a possession. In 1776, everywhere you look, from statutes to dictionaries to decisions from this court to political writings, you find Pennsylvanians and others using the word possessions to describe private land. And I'll just give a few examples of that. William Penn's charter, the original charter that granted him the land that became this Commonwealth, granted him the right to, quote, possess and enjoy the land. Webster's dictionary defines possession all the way back at the founding as the thing possessed, land, estate, or goods owned. Early statutes, like the original Great Law that forbade trespassing under William Penn, forbade the forcible entry of homes and possessions, in that context meaning land. This court in Peaceable versus Nichols, 1793, described a Pennsylvania statute as, quote, an excellent safeguard to landed possessions. And John Locke, whose second treatise, of course, helped inspire the Declaration of Rights, wrote about how, quote, possession of land is determined by positive constitutions. The historical evidence in this case is uniform and it's one-sided, and the Commission hasn't presented a shred of contrary evidence. Now, Russo didn't consider any, but Russo wasn't given any by the parties. That's one of the big problems in Russo, is that Russo received deficient briefing. And we can dive into that more under the stare decisis factors, but I want to shift to history, because history doesn't support Russo either. Pennsylvanians cherished, at the founding, landowners' right to exclude from private land, and they rejected arbitrary searches of property. And these are both common law principles. Wakely versus Hart, which is a case the Commission relies on, said that Article 1, Section 8 was designed to incorporate basic common law ideas. One of the most foundational principles of the common law is trespass, the right to exclude people from your private land. And not long after the founding, Pennsylvanians adopted a series of statutes that empowered landowners to exclude the public with fences initially, and then later on in 1905 with no trespassing signs. Of course, in 2019, you also have the purple paint law. And so you have a process over the course of 200 plus years of Pennsylvania democratizing the right to exclude, making it easier and easier. On the question of arbitrary searches, this court, of course, before the founding, rejected them in 1771 and 1774, rejected applications for general warrants that would have given officials unfettered power to search people's private property, which is exactly the power the Open Fields Doctrine gives the Commission today. Now, as for other state cases, I think there are two buckets that matter here. One, states that have the word possessions in their constitution that have actually analyzed the original meaning of that term, because none of the cases the Commission cites from possession states really engage with what the people would have understood that term to mean when it was adopted.
Can I ask you a question? That was really a very good presentation of the history. If you're correct, do we still need the concept of curtilage?
No. No, because curtilage is a possession under our theory. Now, I think curtilage is also...
But isn't curtilage an extension of the protection that's afforded to a home?
I think that's fair. I mean, I think curtilage actually probably falls under both of those things.
Why do you think that? I mean, because I think that's important. I mean, it seems to me that our full-fledged, warm reception of the concept of curtilage would have to mean at some juncture we incorporated the open fields doctrine into the core of our jurisprudence in this area.
The court has certainly embraced the concept of curtilage, but in all the cases where the court is doing that, it's relying on Fourth Amendment doctrine. It's not relying on independent state constitutional doctrine. Look at the Treffs case on which the Commission relies. That's a 1970s decision. They say it applied the open fields doctrine before Russo. In fact, Russo cites it as well. But Treffs cited Fourth Amendment cases. It didn't perform any independent Article I, Section 8 analysis. And the defendant in that case, of course, didn't have standing anyway because he didn't own the property or live there. It was also kind of a fact in that case that the court said the land was, sorry.
So just bear with me on this curtilage analysis. So a police officer is in a hot pursuit, or let's tone it down because that's going to change the example a little bit. Is attempting to stop for investigative purposes someone who's in their automobile. Under our current law, once that automobile and its driver gets onto the curtilage of the property, what happens?
Under current law, a warrant is required to search the property unless there's an exigency.
Okay, so same example, but the driver drives onto what we'll refer to as an open field. Need a warrant?
Under current law, no. But under our theory, yes, because the land is a protected possession.
We would no longer look at the traditional indications of curtilage.
Yes, which is exactly how the courts do it in the 7 states that have rejected the open fields doctrine. I mentioned 3 that use the word possessions in their constitutions. That's Tennessee, Vermont, and Mississippi. All of them engage with that word and say it includes land, therefore we reject this distinction between curtilage and open fields. Warrants are required in those states to go onto private property that's posted in accordance with state trespass law. And the other 4 cases we cite.
Let me just ask you, have we not adopted the concept of curtilage to be an extension of the privacy that's afforded to the home?
The court has done that, but not in cases involving an independent Article I, Section 8 analysis under the Edmunds factors outside of Russo.
But haven't we said that the law of curtilage is coterminous under the Fourth Amendment and Article I, Section 8?
I think that's probably right, although I don't think the court has independently analyzed the question of open fields under Article I, Section 8 because it hasn't been presented with the opportunity to consider it outside of the Russo case. I think this court gives the court that opportunity.
Can I ask you, counsel, do we have to complete? You said something interesting about posted. If in order for us to recognize Article I, Section 8 privacy in the possession of land, is there a certain CATS analysis that we have to do? Can we say open fields is still alive and well? However, if the owner exhibits a subjective expectation of privacy, posts it, fences it, purples it, all that stuff, then that is an interest that society is willing to recognize as reasonable. But if they truly have an open field Article 1, Section 8 protections don't apply.
That is our theory of this case. I don't know if I would use the word cats for that, but this
Cats being,
Sure.
you don't want to talk about the federal precedent.
I understand, but that is our theory of how this would work in practice, because the properties at issue here are not open fields. They are closed woods, right? It's a difference in kind. And in all the states that reject the open fields doctrine, all of them, whether they're possession states or states that, like Pennsylvania, have a heightened regard for privacy, recognize that when somebody takes the steps required under state law to exclude intruders, it makes it reasonable for them.
Okay, so you're not arguing then for a categorical expectation of privacy. You're arguing for a chance to prove your expectation of privacy, and that these indicia you're mentioning establish that, or can establish that.
You have it exactly right, and I think this is actually the way the court approaches cases involving personal possessions already, because the court said in the White case in the 1970s, in Sell as well, that if somebody owns a piece of personal property, like a suitcase in many of these cases, they have a right to privacy in that unless they, quote, meaningfully abdicate their control over it. I think that somebody that has left their land completely open to the public has abdicated their privacy interest in that property. But of course, that's not what we have with the clubs in this case.
Let me ask, what is the business form of your client?
These are corporate entities, they're hunting clubs, they're...
What right of privacy does a corporate entity have? What
Well,
reasonable expectation of privacy does a corporate entity have?
Well, in the Blesensky case, that involved, waste disposal facilities, and this gets into the policy prong as well. That case involved the intersection between Article 1, Section 8 and Article 1, Section 29, the ERA. The court didn't just skip past Article 1, Section 8 because you had a corporate entity involved. Instead, there was a challenge to a warrantless inspection statute for these waste disposal facilities. They had presumptive Article 1, Section 8 privacy rights. That's what the court,
But they were exercising those rights on their own behalf. Your client is bringing this challenge really in the name of their members, is it not? I mean, that's
No.
not how it's pleaded.
No. The clubs themselves have a right to the clubs act through their boards, and the boards make decisions about what the rules are and who's allowed on the properties, and decisions about posting the property, for example. And so, yes, these are corporate entities, but they have Article 1, Section 8 rights, just like the waste disposal facilities in the Blesensky case. And I just want to add one point about Blesensky. The court did recognize in that case that we have a warrant presumption that applies to these. The court went on to apply an exception to the warrant requirement that was informed by Article 1, Section 27. But what the court didn't do was sacrifice Article 1, Section 8 to Article 1, Section 27. Instead, what the court did is what this court does in every context, which is to harmonize all the parts of the Constitution and make sure that they work together. And perhaps if the commission had invoked an exception to the warrant requirement, we would be talking about how Section 27 informs the application of that exception, but they haven't raised one. And so they have to rest on the idea that whenever Section 27 is involved, Section 8 goes by the wayside. That's not true. And we know it's not true because of Blesensky, but we know it's not true as well because of the West Mifflin case, which involved the intersection between the Commonwealth's duty to promote an efficient system of public education and the more narrow prohibition on special laws on the other hand. And the court didn't say that we can ignore the special laws prohibition because there's a general duty to promote a system of education. What the court said was, let's harmonize these two. You can promote your system of public education, but you can't do it in a way that violates a more narrow prohibition in the Constitution. And the exact same thing is true here. We fully concede that hunting laws are important. The ERA is important. The Commonwealth has a duty to enforce these laws. It has to follow a constitutional process. So I don't think any of the Edmunds factors, Your Honor, support the Russo case or the open fields doctrine. And I want to shift to stare decisis. And what
Before you move on from that balancing test, how would you suggest that would work in this case? The protection of wildlife and the protection of your client's right to privacy.
Right, so under our theory, the game wardens would have to establish probable cause and get a warrant. I see.
But what if they're just trying to determine whether or not there are deceased or rabid animals on the land? Then what? I mean, they can't do that?
I still think they're going to have some reasonable suspicion that there's an issue there. If it's not, if it's the enforcement of a criminal law, that's one thing. If it's, an administrative kind of search to see if there's a deceased bear on the property, the way that would work is you would go to the club and you would actually ask them, do we have your permission to go on and go find the bear? And that actually happened in one of my clients' cases. They allowed the game warden to come on to deal with a rabid bear. They don't have an issue with working with the game wardens. What they have an issue with is warrantless fishing expeditions and the installation of spy cameras on their properties. And I think this gets into stare decisis because the Russo case, the court typically asks for a special justification for revisiting precedent. I think we have that here because neither of the parties in the Russo case gave the court the evidence it needed to get this question right. And Russo itself, in the decision, I think planted the seeds of its own demise. In footnote 11, Russo said that state constitutional decisions are on their strongest footing when they proceed from a searching analysis of all four Edmunds factors. That was a point Justice Mundy made in her dissent in the Alexander case. And so I think all the justices on this court have written at separate times about the Edmunds factors are important. People have to brief those. And Russo called out the parties for failing to brief them. The Commonwealth didn't brief any of the factors. If you go read its brief, it's basically just a list of bullet-pointed facts. And Russo himself, the court said, failed to make any textual argument for overruling the open fields doctrine when that's the whole basis of the federal doctrine, is the plain text of the Fourth Amendment. There are, of course, other stare decisis factors. I'll just go through a few of them. Workability, I think Alexander soundly rejects the idea that a rule is workable if it's convenient for law enforcement officers, but then systematically violates everybody's Section 8 privacy rights. Same with reliance interests. The Commonwealth doesn't have any interest in violating Article 1, Section 8, whether they've been doing it for 100 years or one day. The age of the decision. Russo is pretty young. It's not even out of high school yet. I think Russo hasn't engendered any, future precedent the court has to worry about overruling. This court hasn't cited Russo for its substance, at least on the open fields question. No published Pennsylvania appellate decision cites it. It's relatively an outlier in this court's jurisprudence. And the last factor, coherence with precedent. Prior to Russo, this court recognized that ownership and the right to exclude from real property, this is the Gordon case, creates a privacy interest in that property. Russo went the other way. Prior to Russo, the court recognized that ownership and not giving up control over personal possessions was enough to have privacy in those. Russo went the other way for landed possessions. And finally, prior to Russo, the court recognized in Ikes that game wardens don't have some kind of get out of the Constitution free card. Russo, of course, went the other way. I guess just to conclude, unless the court has any further questions, the court said in Alexander that overruling Gary corrected a constitutional anomaly, that when people entered their cars, their privacy rights evaporated. And I think overruling Russo would correct another anomaly, that people's privacy rights evaporate on their own land. The Commonwealth Court's decision should be reversed.
I do have a question.
Yes.
Sorry. My understanding from your argument is that an open field can be found not to exist where it is a fenced, enclosed property, physically fenced?
So our theory is that if someone takes those measures under state trespass law or otherwise to indicate to the public their property is not open to intrusion, the open fields doctrine shouldn't apply in that context.
And likewise, I think it's also your argument that in the absence of physical fences, if it's posted or purple painted pursuant to Pennsylvania state law, that also would deem it not an quote-unquote open field.
Correct.
Okay, so if we, on your record in this case, find that your property was not an open field, do we have to overrule Russo?
I think you do, because Russo's open fields doctrine authorizes unlimited warrantless intrusions of lands that are posted and that are fenced. Thank you, Your Honor.
May I ask you, Mr. Wyndham, you were admitted by our court pro hac vice to argue. Is this your first argument before the Pennsylvania Supreme Court?
This is my third.
This is your third. And how long have you been in practice?
I started practicing in 2016. I think I first met several members of the court in
You appear to be a law school intern.
You're like Russo. You're like Russo. You're barely out of high school.
That's right. Well, hopefully that doesn't affect the outcome in this case.
You argue like a 20-year practitioner.
Well, thank you very much.
Let's just say you're not as old as the common law.
You're always welcome in our courts.
Thank you, ma'am.
All right, let's hear from Mr. Kowalczyk.
Good morning, Your Honor. My name's Anthony Kowalczyk. I'm a Deputy Attorney General for the Commonwealth of Pennsylvania. I have the privilege of representing the Pennsylvania Game Commission and Game Warden Mark Greitzer, who's been sued in his official capacity.
Counsel, I just
yes.
want to say I do appreciate the Attorney General's office appearing and defending the constitutionality of these statutes.
Thank you. It's a great honor to do that. It's a duty imposed by the Commonwealth Attorneys Act. And also, in this particular instance, we're also representing the parties sued as well. So there are really two reasons why I'm here: to represent the Commission and Mr. Greitzer, and to defend the constitutionality of the challenged statutes. I'm going to start with stare decisis, and I note that in response to Justice Mundy's question, Mr. Wyndham just conceded that his position is foreclosed by precedent. So Russo forecloses the relief that they seek. They seek declaratory and injunctive relief.
Foreclose is a strong word, though, because he's asking us to overrule Russo.
He's asking for that, but he's not trying to distinguish Russo. He's acknowledging that if Russo remains the law as it should, he loses. So
Acknowledging that if Russo remains the law, he loses.
that's correct.
Not if, as it should, but yes.
Yeah. So
Do you think the landscape, though, changed post-Russo when SCOTUS decided Jones? The language in the majority and minority opinions in Jones is quite strong and would seem to cast some, and SCOTUS has not addressed open fields post-Jones. So whether on the four-justice concurrence on expectation of privacy, a la Katz, or the majority opinion on trespass, it seems that a re-examination of open fields is definitely invited by that case. Wouldn't you agree?
I don't think so, Your Honor. I mean, I think the U.S. Supreme Court has consistently adhered to the open fields doctrine since 1924. It was announced initially in Hester. They've adhered to it. Katz was decided in 1967. They reaffirmed it in 1984 in Oliver. There's a 60-year gap there. And this court in Russo, basically, the point I want to make, starting out with stare decisis, is they're not asking you to simply reverse Russo, a 2007 decision. They're asking this court to jettison over 100 years of precedent. The statutory predecessor to two of the three provisions that are challenged in this case was enacted in 1923, as I explained in the brief. And
There's another area of law. I understand your argument about precedent. I think that the court takes that seriously. Speaking for myself, I take it seriously. I know my colleagues do. But where else in our law is there a categorical preclusion where people are never allowed to even attempt to show an expectation of privacy? I mean, our cases make clear that even in a hotel room that you're renting for a night, or a rental car, or a visit to another person's house, you at least get a chance to show an expectation of privacy. Here, this club could have owned this property for 200 years and could have erected all kinds of barriers to boot. But categorically, you're saying they can never establish an expectation of privacy beyond the bounds of some inchoate curtilage line.
Justice Weck, the key word is reasonable. It appears in Article 1, Section 8, and it appears in the Fourth Amendment as well. And that's the key question. It's not just expectation of privacy, it's reasonable expectation of privacy.
That's why it's not reasonable to believe that property purchased and owned is now being invaded by the government without their knowledge or approval or an exception to the law.
Well, it's not reasonable because reasonable people wouldn't expect the woods, an area where you hunt, where they hunt. Where they hunt. Admittedly, it's yeah.
Because I have a hypothetical. If I have a vacation home, do I lose my rights of privacy because I happen to live on the beach?
Well, I think you don't lose the right to privacy. There are two different things we're talking about here, okay? Because the law of trespass does keep out, members of the general population. The fact that a game warden can go onto the property and search the property does not mean that.
Put up a camera.
You put cameras
Mm-hmm.
on the property. What gives you that right?
You did.
They have. I understand, Mr. I understand that you're referring to Mr. Greitzer, but he has a duty to enforce the hunting laws. The cameras were put up in February 2016 to detect, I believe it was the illegal feeding of elk, and those situations where somebody is engaging in activity that is potentially.
You have the information that there's this alleged illegal feeding of elk. Why didn't you get a warrant?
Because the law says that a warrant's not required, and this court's decision in Russo says that there's no requirement. So my
That's the question is, we understand that's what the law says. We're here to discuss the constitutionality of that. The point is, you're saying, Justice Dougherty was asking about, affidavit facts you could put in to apply for a warrant, and your answer is, well, the law doesn't require it, and a response from us might be, well, why shouldn't the law require that given our Constitution? Because categorically, you're saying, under all circumstances, categorically, no matter what, Greitzer and anybody else under this games code could just walk on, film, do whatever. And why shouldn't our Constitution be understood to demand more than that?
Well, because if you apply the rule of construction that was applied in Russo, that was also applied 85 years before that, and you read the language of the Constitution to interpret possessions in a manner similar to those that come before it, rather than in a broad sense that renders the other enumeration unnecessary, you inevitably come to the conclusion, as this court did in Russo, that possessions in the constitutional sense is not read as broadly as they suggest.
First, I want to be clear. I don't think your client did anything that they weren't allowed to do under Russo. I don't think you should interpret our questions as, I think the facts are what bring us here, but they followed Russo. How do you square your point about possessions from a constitutional sense, not including property, with Article 1, Section 1 of the Pennsylvania Constitution?
You mean Article 1, Section 8?
1.
Section 1.
The right to possess land.
To possess land.
If you can possess land, then land's a possession from a constitutional sense.
They're right, and the state police, the Pennsylvania State Police amicus brief explains how the term private property has been used in other contexts in a broader sense, like in Article 1, Section 10, the takings provision. So if the framers wanted the word possessions to mean every single thing that is owned, including real property, it would have most likely used other phrases like private property.
I could say if they didn't mean land to be a possession, they wouldn't have said you have a right to possess land. You have a right to own land. You have a right to take land. You have a right to do a lot of things. But I'm hard pressed to say that in Article 1, Section 1, they talked about land as a possession, but in Article 1, Section 8, they didn't.
Well, in Article 1, Section 8, it specifically speaks of privacy. You're talking about situations speaking to ownership, what you can procure. And the expectation of privacy is going to be different depending on where you are and what you're talking about.
Well, that brings me to the point about that Mr. Wyndham made about our case, our opinion in Alexander, where we overruled a rather recent precedent, Gary. And I wondered if you could talk about that for a moment.
Are you talking about in terms of stare decisis, or
Yes,
well? I mean,
in terms of expectation of privacy.
I think Gary, if I recall, was actually not even a majority decision, and Alexander noted that. Russo, of course, was a majority decision rendered by the full court. So that's one distinguishing factor. The other situation here is there's no question someone has a reasonable expectation of privacy in an automobile, and I don't think the U.S. Supreme Court has questioned that. The automobile exception was established because of the ease through which someone could get contraband out of the way, and this court merely said that it wasn't going to apply a categorical automobile exception, that there had to be probable cause, and exigent circumstances to justify the warrantless search of the automobile. I think that's a situation where there's no question there's an expectation of privacy. The automobile clearly would fall within the ambit of both Fourth Amendment and Section 8 protection.
Well, why do you,
What we're-
going back to Justice Doherty's question, which I'm not sure you had a chance to answer. You post the property, you fence it, you purple paint it. You put, on any access roads, you put gates. You're saying that in Pennsylvania, Pennsylvanians don't believe that is both a subjective expectation of privacy and that Pennsylvanians would believe it to be reasonable.
I don't believe it would be reasonable. We're talking about 5,500 acres worth of property. I'm combining Pitch Pine and Punxsutawney.
So there, my next question, if you're gonna point out how many acres, I'm gonna ask you how many acres is enough.
How many acres is enough?
There are too many.
Well, I think
At what point in time do you own too many acres to have a reasonable expectation of privacy?
Well, I think that, I don't know the answer to that question, but I think Justice Donahue's question earlier about, Mr. Wyndham conceded that his position would essentially eliminate the concept of curtilage. And I think curtilage has been...
Curtilage was created by the United States Supreme Court because the Fourth Amendment refers to homes.
Oh, and it's considered part of the home.
Our Article 1, Section 8 does not refer to homes. We don't need curtilage. From a federal constitutional perspective, they need curtilage. We don't need curtilage.
Although we have curtilage.
We have curtilage, but
That doesn't mean that we have to maintain
we
them.
can give up our curtilage.
Never been fond of
But
curtilage.
I'm just struggling with this idea. I mean, if you're in rural Pennsylvania and you own multiple acres of property and you go to the expense of posting it and signing it and even putting gates up, I'm struggling with the idea that Pennsylvanians wouldn't think that you have a reasonable expectation of privacy in that.
well, you don't have a reasonable expectation of privacy in the sense that law enforcement can't come in, because I think you have to look though to the content of the law to some extent. I mean, I think what their argument is premised on the law of trespass, which has consistently been decoupled from the constitutional test under both the Fourth Amendment and Section 8, both in Oliver and in Russo. And the expectation of privacy that you might have has to account for existing law, which allows warrantless searches of open fields.
But it's circular. I mean, your argument is categorical. So, when your argument, as I understand it, sir, it would make no constitutional difference, because your argument is categorical, that it's 55,000 acres or 1 acre. Because under your understanding, the law is the law, and the law says the game warden can go on and march on and do whatever, put up a camera, search, et cetera, as long as it's not the home or the curtilage. And it doesn't matter what the facts are, because you're saying categorically they don't even get a chance to show that they have an expectation of privacy that would require you to get a warrant. Am I right?
That's correct, but you qualified it correctly by saying the home or the curtilage. But I do want to point out that this statute we're dealing with here, it doesn't just talk about homes, it talks about buildings. So we're not just talking about houses. Buildings are outside the scope of the warrant, and there's a separate provision, subsection 9, which is not challenged, which allows the game warden to secure and execute warrants to search buildings. So,
one more follow-up then. What about Justice Doherty's hypothetical of his vacation? So he goes to the expense and trouble of renting a really private, large acreage. It's forested, heavily forested, and in the middle of that forest is a wall. And inside that wall is a swimming pool. And he likes to skinny dip. And so, but Mr. Greitzer could walk on, I'm joking, of course, but Mr. Greitzer could walk on and put up a camera. There's no building there. There's no home. And he's entitled, and the point is, the person enjoying that pool cannot even attempt to show any expectation of privacy. How does that square with the Pennsylvania Constitution?
well, I think that the hypothetical you gave actually illustrates the point we're making here. Okay, a reasonable person would not believe that going out and doing things that you would only do in the home are reasonable to go out and do in the woods.
Is that reasonable for a hunting club to go through their own property that's posted to hunt or do whatever they choose to do?
Not with that. Well, first of all, it's worth noting, and we're not qualifying the open fields doctrine by what I'm about to say. But hunting is obviously a dangerous activity. It involves the use of deadly weapons.
That's why
So
game wardens
that,
shouldn't be wandering around with them.
well, and I think game wardens need to make sure that the hunting laws are being enforced, and they also need to make sure that wildlife's being protected and not unlawfully baited.
It's analogous to people cooking meth in their house. You can't put cameras in their window. You can't walk in the door and say, we suspect you're cooking. You gotta get some reasonable suspicion or probable cause and execute a warrant, other than the statute that's before.
We're not saying, pardon me, Justice Doctor, we're not saying that it's not within Pennsylvania statutory law to do what the game wardens are doing. We're saying that law may well be unconstitutional.
Well, I don't think it is. I think it's important to note, Mr. Wyndham said that Russo was poorly briefed, seems to think that Russo, was basically a rushed analysis. Moving, to the Edmonds factors, I want to point out a very important thing here, okay? Russo's articulation of the intimate objects about one's person to construe the word possessions in Section 8 wasn't just dreamed up in a vacuum. It actually predates Hester. The Court of Appeals of Kentucky articulated that in 1922. That's before Hester, before the U.S. Supreme Court announced the open fields doctrine.
That's even older than the common law.
1922.
I'm just using the Holmes thing.
Holmes was referred to the open fields doctrine as older than the common law, and that was the Brent decision, 1922. And we know from the article authored by President Gormley and Professor Hartman, the 1991 Kentucky Law Journal article, the Kentucky Constitution's Declaration of Rights was copied from ours, and the Kentucky Supreme Court specifically took note of that and looks to this court's decisions more so than any other court for guidance on interpreting their Declaration of Rights. So basically, the textual analysis and the rule of construction that this court applied in Russo in 2007 was exactly the same as the rule of construction applied in Brent by the Court of Appeals. And
The problem I have with some other questions about Russo is the language of our text is different from the U.S. Supreme Court's text. The text is different.
Effects and possessions, that's the only meaning, that's the only difference that I think we're talking about.
Understood.
Mm-hmm.
I don't think many people would think of land as an effect.
No, I think Oliver makes it very clear that the word effect does not include real property. So I think that takes it outside of Fourth Amendment protection. But I think when you move to the situation we're dealing with here about whether there's a reasonable expectation of privacy in an open field, I think the answer is clearly no. I mean, the only case they have.
Do you agree that land's a possession?
Not for purposes of Section 8. I mean,
For what purposes?
Well, I think legal terms of art are don't usually use if we use the common ordinary meaning of words, we wouldn't have legal terms of art. That's why we
You understand that our Statutory Construction Act requires us to ascribe the ordinary meaning to
well, yeah, unless a contrary context plainly appears, but the Statutory Construction Act would control the interpretations of the statutes, not the Constitution.
Wasn't this place one of the Crown's possessions conveyed to William Penn, and whereupon it became his possession?
This place,
This state, this Commonwealth, Pennsylvania, Penn's Woods. It was a Crown possession.
Mm-hmm.
We referred to all these places in the colonies; they were all Crown possessions, weren't they?
Yes, and I think the breadth of the rule they're asking for illustrates its unreasonableness, because if you interpreted that broadly, then everybody would have a quote-unquote reasonable expectation of privacy everywhere, and every concept, like Justice Donahue was talking about curtilage would have to be discarded. The only case that they have that they claim to supports their contention that the right to exclude creates a reasonable expectation of privacy is the Gordon case, and Gordon didn't have anything to do with it. Gordon involved a stolen purse by a thief who was residing in someone else's house, an abandoned house, and when the purse was discovered during a warrantless search and the defendant tried to suppress it, this court said that he had no reasonable expectation of privacy because he had no right to exclude others from the home that he was unlawfully occupying. I think...
Let's talk with that for a moment.
Okay.
This right to exclude. Pardon me. I belong to a hunting and fishing club in Westmoreland County. The grounds are posted. The club spends a lot of effort making sure that trespassers do not enter onto the club property for a variety of reasons. They have a right to do that. They have a right to exclude anyone who comes onto the posted club property. Why not? Why, in what circumstance would it be that the club does not have the right to exclude game wardens?
Well, first of all, it's important to note that they don't own the wildlife on the property, and the gate. Well, see, but the gate. I'm sorry. Go ahead.
It's a different issue, and I mean, if you accept the proposition that land is a possession in terms of our Article 1, Section 8, then we could start talking about, are there exceptions? Is there some balancing test that has to take place? But if land is protected by Article 1, Section 8, we're on a totally different playing field than what we're dealing with in Russo.
Well, obviously, we're not arguing that there's for an exception to the warrant requirement. We're arguing that there is no warrant requirement, and that's the existing law that's been in effect for 100 years. So that, I mean, that's why we're not specifically trying to argue for an exception to the warrant requirement. Our position is we don't need one. But
we're here on a challenge to that existing law. I mean, just assume for the sake of argument, we overrule Russo. Then we are in a different world. Russo talked about Article 1, Section 27.
Yes.
But in a prohibitive sense. They talked about it to justify, in part, the conclusion that open fields were not protected. I mean, that's a, backward analysis.
Well, I don't think it is, because the ERA, Article 1, Section 27, as this court explained in Robinson Township, actually imposes, it's unique.
But we have to get past this position that you continue to take, and I'm not certain why, because your brief really didn't assert a very strong argument as to why land is not a possession. Because if it is, then Article 1, Section 8 kicks in. That would be end of discussion. You could then talk about what are the parameters, if there are reasonable expectation of privacy, do we apply a trespass analysis? But we have to get over this hump as to whether or not we're talking about something, in your view, that is actually protected by Article 1, Section 8, the possibility that it is protected.
The possibility that the land, well, I think if you...
It all hinges on whether you view land or we view land as a possession.
Well, even if you do, I think it's important to note that, in the, 18 years since Russo, nothing has changed in terms of the, looking to the third Edmunds factor, to other states. Every single state that they rely on that's on their side, and there are only 7, there are 10 on our side, every single state that they refer to had already taken the position before Russo. Russo already accounted for that. Now, North Dakota, there's one case where a new state has joined our side, and that's North Dakota, the Mitteleider case in 2011, and that case particularly addresses the question that you seem to be interested in about fencing. The North Dakota Supreme Court in Mitteleider applied the open fields doctrine and specifically said that the fencing did not create a reasonable expectation of privacy when it was put around a farmstead. And I think that the important thing to keep in mind is what they're asking you to do is to literally equate the woods and open fields with the home. There wouldn't be.
I'm not sure that's right. Aren't they saying they don't want a categorical preclusion of an opportunity to demonstrate an expectation of privacy? So that they're not arguing. I don't take their argument to necessitate a reversal predicated on a categorical determination that all lands are always private, but rather that your argument that categorically they can never demonstrate that goes too far under our Constitution. Am I ascertaining the arguments?
If that's their argument, I think I interpreted their argument to mean that any land that they own is a possession, and therefore the warrant requirement would kick in. I think
steps to demonstrate that it's not an open field, right? If they take steps to demonstrate possession, such as fencing or a posting, purple line.
But I think what that would lead you to is into, an area in which the standard would become unworkable. Because it would then become virtually impossible to distinguish an open field from a situation in which there is this concept of a land that's not enclosed that has a reasonable expectation of privacy.
Officers do this they do this every single day. How do they, under your rubric, how does Game Warden Kreitzer know where these open fields end and the curtilage begins? How does he know? Does he have a magical, you understand.
Curtilage is the area very closely associated with the home, and I think that these statutes actually carve out buildings.
And curtilage.
And curtilage, but the curtilage is already, my point is that even if a building would not constitute a home, it still is not subject to, it wouldn't be a house for purposes of Section 8, but it would still be a building, and it would be immune from.
The question that was asked, I mean, how would a property owner define the area that they perceive to be private from intruders? They post trespass signs, correct?
That's the purple paint that the club.
So why isn't that good enough? I mean, you're saying it's unworkable. Why would that be unworkable?
Because the area is so large that that the game wardens wouldn't be able to enforce the hunting laws. They might know where the purple lines are, but when you're dealing with 5,500 acres, it's difficult to imagine a scenario in which a game warden would be able to enforce the laws. I mean, animals obviously are not going to call the game commission and report hunting violations and say.
He already has some reasonable suspicion of elk baiting, right? So if he can't quite get the probable cause with that, why can't he send up a drone?
Are you talking about under the laws that presently exist, or under the hypothetical?
I'm saying if we said that just like other law enforcement officers, these folks should have to get a warrant. If he needs probable cause for a warrant.
To put up a drone?
Mr. Greitzer, I guess, let me put it this way. I take it that Mr. Greitzer needed to forage around and put up the camera and walk around all the time because he didn't have probable cause for a warrant if the code didn't give him this authority to walk around. Does that make sense?
I'm not sure I understand what you're asking.
Would absent this statute sort of authority, would he have had probable cause for a warrant?
I don't believe so necessarily. I think that.
What more would he have needed, in your view, under a warrant regime, absent this code, for example? What more would he have needed to go in front of a magistrate and get a warrant to go onto the premises and search for this evidence?
Well, he would presumably need some sort of information that a hunting violation was occurring. Subsection 8, well, he has it because he's been patrolling pursuant to the statute. And that's how this evidence was uncovered. Now, we do have we have a subsection 8, one of the challenge provisions allows administrative inspections when there's prima facie evidence of hunting. Okay, I think probable cause to believe that there's criminal activity afoot would probably require more than simply the fact that they're hunting, because hunting is a lawful activity. And that's why I think it's critical that the game wardens be able to go and patrol without the need to get a warrant.
I want to acknowledge the point that you're making, because it's a very important point, which is if we do revisit Russo and we do revisit this open fields doctrine and change it as the petitioners want us to do, it will make it harder for game wardens to police compliance with our hunting laws and fishing laws, for that matter. There's no question about it. The issue, though, is does the Constitution demand it nonetheless?
It does not. And I think if you look at this court has consistently recognized that the ERA counsels against an interpretation of other provisions of the Declaration of Rights that would interfere significantly with that authority.
I'm a little nervous about you keeping invoking the ERA with regard to private land.
Well, if you take a look at Robinson Township, it specifically cites Blazinski disposal for this very proposition. And that was a case, Blazinski disposal was a case where this court said that the open fields doctrine didn't even apply. That was a building.
That was with regard to potential seepage into under
solid waste,
solid waste. We're not talking about solid waste that can migrate to other properties and water sources and things like that that are protected by the ERA. We're talking about purely private property, and there's no indication that somehow, some way, you were entering the property to police some effect on other property that belonged to the trust.
But you're policing the property to protect wildlife.
To protect.
Which is protected by the ERA.
ERA. And not only is it protected by the ERA's self-executing provisions, but as this court explained in Robinson Township, the legislature has an affirmative obligation to act to protect the environment through legislative action. So
within the parameters of the law.
Within the parameters of the law, but I don't think that it's reasonable to interpret Section 8 in a way that it would put it on a collision course with Section 27, and that factored heavily into the analysis in Russo under Edmunds Factor 4.
This is a very important case, and it's a very interesting case, and we understand both arguments, and we will take it under advisement. Thank you both.
Thank you, Your Honor.
Mr. Minner, would you call the next case?
Jack and Jeffrey Duncan versus Chartiers Nature Conservancy. Representing the Conservancy, Mr. Vincent Coppola. Representing the Duncans, Mr. Michael Fives.
To consider the proper means by which this suit may be brought under our rules of civil procedure, specifically whether it may proceed as an action to quiet title under Rule 1061B2, where the evidence is conflicting as to which party currently has possession of the property. We also consider whether the trial court must first determine whether the parcels at issue constitute unenclosed woodlands under the Unenclosed Woodlands Act in order to establish its subject matter jurisdiction over the adverse possession claim. Please proceed.
Good morning, Madam Justice Todd and Associate Justices. I am Vincent Coppola on behalf of the Chartiers Nature Conservancy, a tax-exempt organization, the purpose of which is to acquire by possession undisturbed natural habitat for use by the public at large for passive recreation. One of the questions on which this court granted a la carte appears to be an issue of first impression, notwithstanding at least 140 years of jurisprudence in this particular context. And that is whether the subject matter jurisdiction of the trial court was ousted when the trial court concluded that the possession of the properties at issue was less than clear or shared to some extent between the parties, and then on top of that conclusion, declined to apply a legal presumption that possession of real estate is to the person who holds title to that property. Now, to crystallize how the trial court varied from this court's decision in Mildred versus Nye, I believe it's helpful to have a brief statutory context. There was no right at common law for a possessor of real estate to go into court in one's own right and seek to quiet title by adverse possession. That changed with the acts of 1889 and 1893, both of which are the direct statutory progenitors of current Rule of Civil Procedure 1061B. It was only pursuant to those acts that a statutory basis was given to a potential adverse possessor to initiate a battle that the common law did not allow at that time. However, the statutory opportunity for such possessor required at the outset that that person had to allege and have possession of the property. Now, a respondent could come into court and object to the allegation of possession. That triggers a hearing in the trial court to determine who has possession, because if the trial court determines that the original petitioner has no possession, then the trial court is without power, without subject matter jurisdiction, to order the respondent to file a complaint in ejectment.
Can I just jump in there? I was struggling with this concept of the trial court being without jurisdiction, because it seems to me the trial court has jurisdiction over actions to quiet title. They're not vested in the Commonwealth Court or the Superior Court or the magisterial district judges or this court. You quiet title in common pleas courts.
Yes, Your Honor, of course. But in this particular instance, in order to have initial jurisdiction to trigger an ultimate trial on the merits, case law, this case, court's decision in Mildred, that's front and center in importance here, and I'll turn to in a moment, requires that the petitioner have possession.
Why isn't that standing? Why is it jurisdictional?
Simply because this court has said it is, and because of the common law antecedents. Because there was...
I just think it's, my personal view is I think it's kind of sloppy language. I mean, I think really the statutory provision, which I thought is still actually in effect, and our rules say pretty clearly, only a possessor can bring an action for adverse possession, right?
Yes.
That is a standing issue. That says who can bring an action, not the court's jurisdiction over those types of actions.
I think the court may be conflating to some extent the concept and where the requirement of possession fits into the court's jurisdiction. There is no question under Mildred and all the antecedent and post cases after Mildred that possession is an initial trigger for statutory jurisdiction, that without possession, the petitioner cannot go into court under originally the Act of 1889 or 1893.
You're not telling me why that's different from standing.
It's sort of like a Venn diagram. There's the two circles that converge, and the middle ground. We were in second grade. We had to color in the middle. It's a subset. Yes, one needs standing. One needs standing to be in court on any number of issues. But in this particular context, the statutes of 1889, 1893, which are now part of the Rule of Civil Procedure 1061B, possession is a requirement. Possession, not simply standing, but possession.
You have to be in possession to bring the action.
That's why the trial court is obliged to have a hearing on this issue. That's why the trial court must do that. And in this instance, if there is no possession, the trial court does not have the power to continue the case and thereby order the respondent to file an action in ejectment. Now, the trial court's decision in this case, if it was correct on the issue of possession, then it was also correct to order the Conservancy to file a complaint in ejectment. The problem in this case is because the trial court committed solely an error of law when it concluded that a certain degree of shared possession could satisfy this court's requirements articulated in Mildred and many other instances. And that goes to the issue of some degree of shared possession. And it's that shared possession which destroys subject matter jurisdiction and ousts the jurisdiction. And
Why would that be? I mean, in any action for quiet title, you're going to have two people, entities, claiming possession. When you say shared, what do you mean? Do you mean something other than a contest between two people claiming possession?
yes, indeed, this court in Mildred uses the phrase contest to examine whether there is jurisdiction.
Yeah, but you're saying that the trial court erred because it found shared possession.
Yes.
Why is that? Why is that at its heart incorrect? In order to proceed, isn't that what he would have to find in order to proceed?
In order to get to the next level of the litigation, there must be possession in the petitioner. And it goes back again to the historic antecedents. There was no common law right for a possessor who did not hold title to go into court and trigger a lawsuit on adverse possession. That was not the right. It was only when the legislature gave that right to such persons under the 1889 Act and the 1893 Act. That's why possession is required, because under the common law, that particular litigant could not go into court. Therefore, the statutory basis of jurisdiction was solely whether the petitioner had possession at the time of the initial complaint was filed.
But here the trial court found that the petitioner here had possession, if not entirely, in part.
Well, that goes right to Mildred, Justice Brobson. I'm going to share.
Well, no, do you agree with that? That that's what the trial court said?
Yes.
That's what the trial court said, and that's what the issue is on appeal, because this court restated in Mildred, and Justice Brown in 1912 is quoting verbatim from an even earlier decision of this court, and says, the possession of the complaining party, as was said in Titus versus Binley, is a jurisdictional fact which must appear before the act can be made to apply.
Right, but you're kind of going past what I just said. You agree that the trial court said that the petitioner had possession.
Shared possession, or it was unclear.
Well, but the statute doesn't say it seems to me, and I remember this is what you're all briefing. You're jumping to them having the burden of establishing exclusive possession, which is an element of an adverse possession claim. That's why I was focusing on standing and not jurisdiction. You don't have to show exclusive possession to be able to have standing to bring quiet title. You have to show only possession. It's then if you bring the quiet title action and you assert adverse possession, you have to show it's exclusive, notorious, open for 10 years, that kind of stuff.
Well, I have to direct this court's attention to the very next sentence. Possession within the meaning of the act cannot be affirmed where between the parties to the controversy there is joint occupancy. So this court in 1912 used the phrase joint, And in 2021, the trial court used the word shared to some extent. Those are synonymous. They both connote a type of mutuality. And it's that mutuality that destroys jurisdiction under this court's decision in Mildred, the cases that came before Mildred, and after. All the cases in this context require possession.
But your analysis precludes anyone claiming adverse possession to claim possession.
No, Your Honor. What happens is the right is now given pursuant under the old statutes.
Okay,
And
that's
now,
what the trial court found here. I mean, that's implicitly what the trial court found here. There's two claims of possession. One is by title, one is by adverse possession. He's going to proceed.
the nuance is, Your Honor, that what the trial court found here was insufficient under this court's precedent, long-standing precedent, to confer possession. It was not enough possession, if you will.
Let me just could you be more specific about that? Are you referring to the requirement for adverse possession in this context, that the person claiming adverse possession has to establish that they cultivated the fields or build a residence? Is that what you're referring to here?
Not exactly. That's pertinent to the second issue on a la carte. This goes before that. In other words, that goes to the definition of possession. If this court holds that the petitioner, that the level of possession that the trial court found to exist here is insufficient under Mildred and all of the cases this court has pronounced over the years, then it is unnecessary even to decide if the court used the correct definition of possession.
Okay, let me see if I honestly, I'm just trying to grapple with what your argument is here. Are you saying that because your client had a title to the property, no one else could claim possession?
No, absolutely not.
Well, tell me what's wrong with the trial court's conclusion that there was shared possession.
I believe there was no shared possession, but let's assume that's why we're here. The trial court has said there was shared possession. My argument to this court, Your Honor, is that shared possession is insufficient to confer the possession necessary, the quality, the caliber of the possession necessary to sustain the subject matter jurisdiction of the court.
What type of possession do you contend is necessary or is required under your argument? I'm trying to figure out what it is you're arguing.
When a trial court...
I didn't ask you about the trial court. What do you contend is the type of possession that is required under the existing case law to confer standing or jurisdiction on the court?
Non-shared possession, Your Honor.
Okay. And what does that mean?
Exclusive.
There would be an element of exclusivity, but certainly, if the trial court determines the property is shared, that evinces a contest, which is the next point from Mildred, which the trial court also runs afoul. Mildred says, it is possession and not the contest over the fact of possession is what the act requires if the provisions are to be invoked. What Mildred was about, there was a simple dispute, boundary line, only 250 feet of property. The petitioner went into court under the 1893 Act and said, I have possession of this property. We want to have a determination of title. We have this dispute as to part of it between neighboring landowners. The respondent went into court and objected, just like the Conservancy did here, and said, petitioner does not have possession, which is the triggering factor for jurisdiction. We, respondent, have possession. The trial court conducted a hearing and held that it was the respondent, in fact, that had possession, or the last one to have possession, at the time the petition was filed, and then dismissed the case. That went on appeal to Superior Court. Superior Court examined the record and said, oh, we believe there's a substantial dispute, that was the term that the Superior Court uses, substantial dispute of possession, and remanded to the trial court to make the rule of the rule absolute. And that was the old way it was done, a rule to show cause. On appeal to this court in 1912, court said that It does not matter. In fact, using the words that the trial court cites, as there must be possession to give the court its purely statutory jurisdiction, it cannot acquire jurisdiction where there is a mere contest, however substantial, as to the fact of possession in the petitioner. What the Supreme Court said was, it's not pertinent how much of a depth of this contest there is, whether it's a substantial contest, as the Superior Court had indicated in that case, or any contest at all. And I think that goes to your question, Justice McCaffrey, that and yours, Justice Robson, what level of possession is necessary. This court has said it does not matter as long as there's a contest, however substantial. That suggests that any contest at all does not trigger or sustain the subject matter jurisdiction of this court.
But there was a contest here. The trial court did conduct a fact finding, and the trial court concluded that they had possession.
Well,
They didn't conclude that they had exclusive possession, which would have to be something that would have to be shown later in the proceeding. But they proved, the trial court found possession.
the trial court articulated what it found and used the expression shared to some extent between the parties of the dispute, or it was unclear that who had possession of the property. The point is, the trial court did not say that the Conservancy did not have possession of a part of its properties, and that is the problem. That is the factor that ousts jurisdiction. It's the trial court's conclusion that there was shared possession here. And that shared possession...
So what's supposed to happen then? You have, let's just adopt what the trial court said. Shared possession. Who blinks?
The trial court must, well, this court must dismiss the case for lack of subject matter jurisdiction under Mildred and its progeny.
Oh, but how do we quiet the title here?
That's what I'm asking. I mean, the rationale behind you're using the term shared possession, which
The
is
trial court uses that, Your Honor.
the terminology. What it really means is contested possession. In this particular case, the whole actions regarding possession, the whole underlying rationale behind possession is to eliminate self-help. The trial court wants to make that initial determination as to who possesses the property. Therefore, it orders one party to file an action to quiet title, which is the party in possession, for adverse possession, or the other party to file an ejectment action because I'm out of possession. But it wants to eliminate efforts at self-help, to a breach of the peace. That's why we're all getting lost here. What is it because all of these issues are going to be interrelated. Quiet title, adverse possession, ejectment. In this particular case, what is it you're asking us to decide? Because Justice Brobson I'm going to use your terminology, just hit the nub of it. What's going to happen if we send this case back to the trial court? How do you quiet title?
Your Honor, if you accept the Conservancy's position on this particular issue, then it does not send the case back to the trial court for no other reason but to dismiss.
How do you quiet title?
Well, if it's shared possession, one thing that comes to mind, if there is shared possession, then it would be incumbent on one of the parties sharing the possession to go back into court and articulate the portion that is not shared.
What's the nature of the action?
Quiet title.
Well, Section 1061B. I mean, there's several subsections.
That's the question. Is there another subsection under 1061 that someone should proceed under in order to quiet title in this situation? Is that what your argument is?
Not exactly. If one believes one has possession, and for X amount of years, adverse possession, you seek an order of court nowadays, a rule to show cause in the past, to force the title holder, the allegedly non-possessing title holder, to file a separate action as a plaintiff in ejectment against the alleged original petitioner to quiet for ejectment. And it's at that point the now defendant, allegedly adverse possessor, would assert adverse possession as an affirmative defense.
Use the names of the parties here.
Very good.
What are you saying? Who should bring this action you're talking about? Duncan should bring an action in
Dun-
ejectment against your client?
No, Duncan brought an action.
I understand what he did. I'm asking, what should they have done, in your view, in order to quiet title here?
They had to have absolute possession,
Okay.
Exclusive.
exclusive possession. Well, I don't want to use it, I'm deliberately not using a term that the underlying, the 5 famous elements of adverse possession claim. That's different. That's different.
How
That's-
is it different than what you're arguing?
Yes.
Instead of exclusive, you referred to an element of exclusivity. So I need you to clarify that for me.
The Duncans if the Duncans believe, as they do, they have possession of these Conservancy properties, then they,
Portions.
well, they did as they did here.
I don't want to interrupt you. There's a big piece of property. Part of it is fenced in and used by the Duncans. Part of it's open fields. Your client,
That's not true, but go on.
that's what my understanding of the case was. The Duncan files an action to quiet title as to the portions of the property that it occupies and says it uses. Your client comes in and says, what?
That the Duncans do not have possession, that the Conservancy has possessions, and that these properties are completely undisturbed woodlands.
Possession's fact intensive, correct?
Yes.
So if it's an unenclosed woodlands property, has your client taken any action to occupy that property, fence it in? We just got done to purpling, anything along those lines, to either actually occupy the unenclosed woodlands or use the unenclosed woodlands?
Your Honor, that's a good question. It goes to the second issue, but I'll address it now, of course, in response to your question. The reason of being, the only reason that the Conservancy exists is to acquire undisturbed natural habitat for use by the public. How else can a Conservancy, whether it's the Chartiers Nature Conservancy or something as large as the Western Pennsylvania Conservancy, how can a Conservancy ever possess its property when the sole purpose for purchasing the property or accepting it as donation is simply to have that property available to the public for use as passive recreation? Can be no fences. In fact, the Conservancy isn't even permitted under its own rules to erect no hunting signs, even seasonal ones. There is no fencing on Conservancy properties. These are a gift to the public.
Your answer to the question that you don't want to give is nothing. You don't want any action to exist to resolve this dispute over title to this property. Your client is completely happy with the status quo. We asked you a direct question. Multiple justices asked you a question. If you're correct, how does this title to this property get quieted? And you won't answer the question because your client doesn't want any action. Your client is completely fine with the status quo. Right? Am I right or wrong?
I understand your overarching point.
Am I right or not? I mean, your answer to the question is nothing. When there's contested possession over a piece of property, and someone has title ownership and someone wants to assert ownership by adverse possession, there can never be a quiet title action.
If the ultimate determination at the hearing
Is
where
shared
this
possession.
is shared possession,
Title can never be quieted. That's your position.
that particular case cannot go on for
What
lack of
case can
subject
go
matter
on?
jurisdiction.
What case can go on? Nothing.
Not without absolute possession.
Why could not the Duncans bring an action in ejectment against your client regarding that portion of the property that they claim that they adversely possess? They can do that. There has to be a remedy for this situation. So what's wrong with Duncan's bringing an action in ejectment? I mean, what the trial court did here is order your client to bring an action in ejectment.
Yes.
If he had ordered the Duncans to bring an action in ejectment against your client, then we'd be down to a factual determination as to whether or not they indeed have adverse possession of that portion of the property. Correct?
Well, originally I argued to the trial court 4 years ago that
the Duncans should then bring an action in ejectment. Having reviewed a lot of cases, etc., technically, only the possessor can do that. Now, the Duncans claim exclusive possession. If the Duncans, maybe this is to your point, Justice Brobson, or your question, if the Duncans believe ultimately that they possessed even a part of this property, and they need possession to go in under 1061B1, then they could refile their complaint, I suppose, and articulate exactly where that possession is. And then if the trial court says, well, this part of the Conservancy properties is no longer shared, but the rest of it, not so.
We could reverse and remand and allow them to do that, right?
Yes, but to do that, the court would have to conclude that what the trial court's holding is within this court's precedent, not only in Mildred, but many, many, many years, where a contest of possession. Well, if this court accepts that a finding that shared possession indicates a contest, then under this court's language in Mildred, taken from the Earhart case earlier than that,
Contest, however substantial.
however substantial, just there is no jurisdiction. What your court would be doing would then be allowing or disregarding the non-existence of subject matter jurisdiction when all of the other cases say a contest, however substantial. The Duncans, I don't know, I'm not the Duncans' attorney, I'm not being certainly flippant in that, Justice Donahue, but it's if a party needs possession. So if the Duncans wanted to pursue an ejection, I think in that instance they would have to specifically define what portion of the property over which they have exclusive possession. Okay, because otherwise a party not in possession cannot file an action in ejectment. That's why ejectment is from the non-possessor.
I get that. So they file an action in ejectment. Let's assume for the sake of this discussion that they prove that they adversely possess that portion of the property that's at issue. Then what happens? Do they get title at some juncture to that portion of the property? Because, I mean, obviously they want to have record title to this property that they claim that they have been using exclusively for 40 years.
I understand. So Duncans then file the case is dismissed for lack of jurisdiction. Duncans come back and file a new petition, this time in ejectment against the Conservancy for that portion of the real estate to which they claim they have exclusive possession, the non-shared portion. And then then the Conservancy in response to that petition could, in theory, object and say, well, even with respect to the smaller portion now that the Duncans claim, we believe that it does not have possession. Assuming that does not occur, there is a trial.
But that would have occurred in the action for ejectment. The Conservancy would have come in and proven their case that they did not adversely possess that property. I mean, that would all be taken care of in the action in ejectment.
But
if what is at issue there, as my hypothesis is, to get the Conservancy ejected from that portion of the property that they claim they own by adverse possession. Now, how do they get title? They win. Court says you're right. You adversely possess that property. Now, they want to quiet title to that portion. Does the judgment in the action in ejectment quiet that title, or is there something else that they have to do to get titled ownership of that property?
If the trial court has subject matter jurisdiction properly over an action in ejectment, then ultimately there would be a trial, which did not occur in this case because we're not positive.
I made this up.
Right. Then the Duncans would assert adverse possession as an affirmative defense to the complaint in ejectment, and then ultimately, if it prevails, then title would be then disseasoned, I suppose is the word, from the Conservancy as to that portion of the property, and then they would have it. Yes, after a trial.
Can I ask just one more effort at this, because I really don't understand, and I'm very confused as to what you want. Why doesn't this make sense? Trial court says they have partial possession, which means they're in possession because the rule nor the statute limited to partial possession. They have standing. they can go forward. Trial court orders your party to file an action in ejectment. You file an action in ejectment, and you argue immediately, Your Honor, they cannot show adverse possession because you've already established that they don't have exclusive possession. They can't satisfy exclusivity because you previously ruled it's shared. You win. What's wrong with that?
If this court sustains the jurisdiction, that's what exactly will occur. There
Right.
will be a trial
What's wrong
in
with
ejectment.
that? No, but I'm just saying, you've got collateral estoppel. They litigated the issue of possession. The trial court found that they don't have exclusive possession, they only have shared. You're going to win.
No,
Because
no.
you have to get adverse possession, it has to be exclusive.
Yes. But that would occur pursuant to, we were just discussing, in what manner
Why do
could the
you
Duncans...
care? That's what I'm saying. Is why do you care? Because you're going to win anyway.
But
That's
not what
putting the cart before the horse.
That's not what the trial court did. The trial court left for the next hearing an actual determination of the adverse possession, which is the second issue. Your argument is, in this particular context, adverse possession can only be established in a very circumscribed manner.
Ultimately, yes, at the trial on the merits, certainly.
Right, and so there's no collateral estoppel. There was no trial on the merits of the adverse
Correct.
possession. Am I
Yes,
correct?
yes, you are. But in order to have that trial on the merits, like any trial, in any case, there must be subject matter jurisdiction, and the pronouncements from this court for many years say that joint possession, which I analogize to shared possession, just like the child custody case that's a good example. The court will issue an order of joint custody, perhaps joint custody for the parents. We call that shared possession. The parents share the custody. So those are synonymous. And to the extent the finding of the trial court has a concept that is synonymous with joint possession, then that jurisdiction at that moment was ousted and does not exist to have that trial on the merits.
Okay, if you're right, though, if you're right, and we agree with you, then we would say trial court erred, no jurisdiction, case over. Duncans go back, they file an action in ejectment, and they're on their way to establishing what they wanted to establish by this quiet title action. You're saying they chose the wrong form of action to proceed in order to get what they want in this case, which is actual title to that property that they claim by adverse possession.
Yes, but they went in originally, pending now, for adverse possession of the entirety of both of these lots. To the extent it would come in the second time, the issue would be narrowed as to a particular part, and then yes, there would be subject matter jurisdiction, assuming that the Conservancy didn't object as it did to some formal element, because whoever files the petition, the 1061B petition, that party must have possession at the time the complaint is filed.
Why would they bother with 1061B1? Why wouldn't they just bring an action in ejectment?
That is 1061B1, Your Honor.
Yeah, okay, well, why wouldn't they just do that if this goes back? That's what they would do.
The Duncans did that, but they didn't call it Section 1061B1. The trial court makes reference to Section 1061B1 because the trial court put an accurate nomenclature on what the Duncans were trying to do. My point is that with shared possession, as the trial court found, that's insufficient to confer jurisdiction any further. All right, turning to the second issue.
Sum up, I know you want to talk more about the second issue, but could you get to that and sum up?
Yes, by all means. Actually, it's in the context of the second issue on which this court granted allowance of appeal that I asked the court prior to hand up to the justices two trial exhibits, Exhibits 11 and 11A, both of which, of course, are in the reproduced record. Those exhibits are among multiple aerial photographs of this property taken over at least a 18 or 19-year period, one of which was actually just a few weeks before the petition was filed, the complaint was filed in this case. Those photographs establish, and I just gave an example of one because lots of times through the computer or reproduced record, there's some blurriness in them. Those exhibits are identical in every respect except one. Exhibit 11, and by the way, that EX11 at the bottom is in the trial court's hand, is the original photograph. The trial court directed the Conservancy to outline the contours of the two properties at issue. So Exhibit 11A, you'll see there's orange outlines against two. The number in those, one is clearer than the other. One says 198, and that's just the designation of what the Conservancy called its PNC 198 property, is referenced in the record. The other one is the Ardinger 202. I want to note there is no issue of fact, either at trial or now between the parties, that the contour lines on Exhibit 11A and the other A-series exhibits do indeed represent and are accurate as to the boundaries of the properties at dispute. There is no factual issue to the parties there. So based on those photos, the Conservancy at least made a threshold showing that these properties were unenclosed woodlands. The trial court's failure upon that threshold showing was, one, it did not acknowledge that these properties are unenclosed woodlands, and two, did not apply the legal definition of possession for unenclosed woodlands. The trial court's decision was based simply on that this is a different tier of the procedure. So it affirmatively declined to apply the legal definition of possession at this point. It didn't ignore it or make a mistake not to apply it. It just refused, or declined, perhaps is a better word, to apply it. The reasoning the trial courts offer, simply, oh, well, this is a different tier of the procedure, seems to me somewhat formalistic. It certainly doesn't contribute or advance any notion of judicial economy, concepts that this court has articulated time and time again in so many different contexts and many different occasions. The trial court's decision in this regard, it does not effectuate any kind of streamlined judicial administration. It does not ensure uniformity in cases to use one definition one time in the same case and another, and it certainly, worst of all, doesn't present a consistency during the course of the very same case. A claim for adverse possession is a claim for adverse possession regardless of whether it exists at one tier or the other tier in the same proceeding. That's particularly apt in this case because the Conservancy's mission is simply to hold these properties open. The Conservancy's use, if you will, Justice Brobson and Justice McCaffrey, is the use is a continual use, holding these properties open, having them exist, and they're no longer private. Well, they're privately owned, but they are no longer subject to any trespass. Bicycle over them, hike on them.
Game wardens?
Yeah, sure, yes, the game warden. The final point I would make, Your Honor, is that
before you make a final point, if the trial court had decided in the first tranche of this proceeding whether or not these parcels were in fact unenclosed woodlands, something that he put off to the second, would we still be here on the issue that we have? Because then, if he said they are not unenclosed woodlands, they established by whatever reason that, over the course of time, these things grow back very quickly and they had used the property for the purposes that they explained, would that satisfy your argument that the trial court had to make a finding of actual possession as the first element of this case?
yes, but only if and only if this court sustains the subject matter jurisdiction on that completely independent issue that we were discussing for most of this argument. However, if the court upholds jurisdiction, notwithstanding Mildred and everything we discussed here this morning, then yes, the trial court should be obliged, and that's the alternate basis for relief to the Conservancy requests, that if failing acceptance of the argument that there is no subject matter jurisdiction here, then the solution or the request is to send this back to the trial court for determination, one way or the other, if these are unenclosed woodlands, and then also to apply the definition of woodlands, the legal definition of woodlands. Shouldn't a trial court apply, if there is an issue, let's put it this way, if there is a standard that the law articulates applicable to a particular condition of something, of what logic is there? What purpose is served by not having the trial court apply that articulated legal standard to the particularities at stake in that case? One of the reasons I thought this court may have accepted a la carte, especially on that issue, is because that has implications beyond this case. What I just said, Your Honors, it's more than simply a few properties that are owned. By the way, these are not the Conservancy's only properties in its portfolio. But doesn't that go to so many other issues potentially? That we have a law that prescribes a standard applicable to a specific condition, and that the trial court has declined to apply that to that same condition for no other reason that it's in a different tier in the same case. And that's what we advocate was wrong in this case, and at a minimum should be remanded on the issue of unenclosed woodlands. Thank you.
All right, thank you very much. Let's hear from Mr. Fives.
Thank you, Justice Todd. With respect to the first issue, these are preliminary objections. The issue is whether or not the Duncans possess the property. The court clearly found that they did. There is no evidence in the record, not one scintilla, that the Conservancy possessed the property, was ever on the property, had any actual possession being defined as dominion over the property. Clearly,
They have title to the property. They have title to the property, do they not?
they don't have title to these two lots, which of course is
Because
the...
you're claiming adverse possession.
Yes.
But they have record title to the entire property, and you're claiming they don't have possession of these areas that you claim you adversely possess on behalf of your client.
That's correct. We don't have title to that, and we do have title to all the rest, but we actually possess it. Possession is exercising dominion. We have gated it off. There is no way in other than coming over the...
So why did the trial court use the term shared possession?
That is the court did not find that there was shared possession. The court quoted from Mildren that if there is, you can't establish possession, you have to file an action in ejectment. Nowhere does the court say that they're actually possessed. They just say when possession is less than clear or shared by the parties, you have to file an action in ejectment. It then goes on to say that the Duncans have possession. The Conservancy's argument to the court was, no, we have possession because we have a deed, and there is a presumption that the holder of the deed has possession of the property, which is taken out of context because the case law actually says, absent evidence to the contrary, there is a presumption that the title holder has possession. In this case, the evidence that was developed at this trial, there is not one piece that shows that the Conservancy ever had actual physical possession or dominion. The Duncans gated it off, they graded it, they scraped the soil numerous times, they stored trailers on it, they stored equipment on it, they stored the product that they make, which is the dirt. And the court, in fact, found that there were pictures taken earlier that show that it was scraped off. The court also credited the testimony of both the Duncans and Dushak, the plumber, and Mike Sear, who owned the adjoining property, that Lot 198 and Lot 202 were scraped, that they had been scraped off and actually filled because the area flooded. At Hurricane Ivan, it all flooded. So they filled it up to 3 feet. That obviously is not a woodland. Why the court said that when possession is shared, the remedy is an action and ejectment, I think that was only to point out that Nye says you have to file an action in ejectment if you are not in actual possession. The Duncans can't file an action in ejectment because they are in possession. The record is abundantly clear that they have used these properties for over 40 years to conduct their business. All of the witnesses testified that they have used it, scraped it. They're in actual possession.
Counsel, how does a nature conservancy, whose mission is to keep the property open for public use, establish dominion?
They would have to be there.
How does a nature conservancy be there? If that's what I don't understand.
We use the property. We allow people to come down on it. As the court found, the Duncans have excluded everyone from this property except people that they want to come on, such as their fuel trucks and Dushak.
That doesn't answer my question. That goes to whether you satisfied the criteria for adverse possession. I'm asking you, how does a nature conservancy, whose mission is to hold open fields available to the public?
They have to make it available to the public. In this case, it's not available to the public.
Because you've prevented the public from accessing them.
That's correct. And that's the basis of our adverse possession claim.
I'm a little bit confused on this. Could you explain to me why the Duncans can't, on remand or by a new action, file an action for ejectment, an action in ejectment?
Because we are occupying the property. We have dominion and actual possession of the property. Who are we ejecting? Ourselves? There's nobody to eject. We have filed quiet title to say, because we've been there for 44 years, it's our property. But we don't have anybody they're not there.
Well, this goes to my question about what happens, because you're, as I understand the law, you're absolutely correct. An ejectment action cannot be brought by someone who has possession.
That's my understanding.
You have to be an owner not in possession to file an ejectment.
Or have some other right in the property, yes.
Thank you.
Would you like me to address the unenclosed woodlands issue? The unenclosed woodlands issue is a defense that needs to be raised as a new matter. In fact, it doesn't go to whether we have possession. We could possess the property but not be able to acquire it. The statute says you do not acquire a right, and actually it talks about easements, but over the years the court has sort of grafted that onto the whole property, not just an easement. Regardless, it says you cannot acquire property over an unenclosed woodland. You can occupy it, you can have possession of it, but you do not acquire it. That's what the quiet title action is about. Can we acquire title? And if it's found that this is in fact an unenclosed woodland, then we cannot acquire title. I think the court could have made that decision because the record is very clear that this was not an unenclosed woodland.
Well, what about the definition the court used? I mean, is it appropriate to just disregard a technical definition?
Of unenclosed woodland? They're not disregarding it. The court is saying you can bring this up in your answer in new matter. You raised the defense that this is an unenclosed woodland, therefore you cannot acquire title. But as far as possession, it really doesn't have anything to do with it. I could drive your car and I have possession of the car, but I haven't acquired title to the car.
Are different uses of the word possession varying in this case? Did the court switch back and forth in how it defined possession?
I don't think so. It's not in the opinion. There is nothing in the opinion that says that the Conservancy has actual physical possession or dominion over the property. They have argued that we have possession because we have a deed. That's all. Naked title, not actual physical possession, which the case law requires for us to be able to bring the quiet title action. If nothing further, thank you, Your Honor.
Thank you both very much. Mr. Minner, we're going to take a brief recess for lunch. We'll re-adjourn at we'll reconvene at 1 o'clock.
We're in recess until 1 o'clock.
Brian?
person Jamar Foster, representing Mr. Foster, Mr. Dominic Apelt, representing Commonwealth, Jessica Nepa.
Thank you. This case involves shot spotter technology, which is a system that uses acoustic sensors to detect the sound of a potential gunshot, triangulates the location of the sound from multiple sensors within a coverage area, and sends a dispatch to the subscribing police force. Here, a police officer received 2 shot spotter alerts within seconds, indicating that 5 shots had been fired near the location of a particular address in a neighborhood the police considered to be a high-crime area. Upon arriving at that location, the officer observed Aplt in the driver's seat of a parked vehicle with a companion in the passenger seat. The officer observed no other persons in the area. The officer activated the lights on his police car and began to initiate an investigatory stop. Aplt then exited his vehicle and proceeded to walk toward a private residence. The officer ordered Aplt to return to the street multiple times so that he could conduct his investigation, but Aplt continued to walk away. Multiple officers arrived on the scene, and fearing that Aplt might be armed, although no firearm was observed, the officers forcibly handcuffed Aplt, during which time they noticed that he displayed signs of intoxication. Aplt was thereafter charged with offenses relating to driving under the influence and driving while his operating privileges were suspended. He filed a motion to suppress, contending that all evidence derived from his investigative detention should be excluded because the officer lacked reasonable suspicion to detain him. The trial court denied the suppression motion. Aplt was convicted of the charged offenses, and the Superior Court affirmed the denial of Appellant's suppression motion. Both lower courts relied, at least in part, on the shot spotter evidence in concluding that reasonable suspicion existed to support Appellant's investigative detention. In this appeal by allowance, we examine whether the lower courts afforded too much weight to Appellant's temporal and spatial proximity to the shot spotter alerts in assessing whether reasonable suspicion existed to support his investigative detention. Please proceed.
Thank you, Your Honor. Good afternoon, Madam Chief Justice Todd and Associate Justices of this honorable court. My name is Dominic Pietropalo, and I represent the appellant in this matter, Jamar Foster. Your Honors, the Superior Court placed too much weight on the temporal and spatial proximity of Jamar Foster to the shot spotter alert in this case, and in so doing, assumed the accuracy of shot spotter and failed to take into consideration that the alert gave no specific or articulable facts that would indicate that Jamar Foster was involved in any criminal activity himself. Here, the system indicated only the presence of gunfire in the approximate area, but gave no additional clue as to who fired or whether there was even criminal activity afoot.
Does it indicate an actual address when it gives a location within a neighborhood?
Yes, Your Honor, the record supports that.
Okay.
Mr. Foster would not have been seized unreasonably but for his mere presence within the shot spotter spatial response area, which in itself was large enough to have encompassed many more potential suspects.
But he was the only one in the area, right? And his companion in the car.
That the officers in this case observed, Your Honor, but that's going to be one of the main issues.
The officers got there within a very few minutes or seconds?
Your Honor, this is one of the main issues as well. The trial court where I represented Mr. Foster did not issue findings of fact or conclusions of law contemporaneous with the suppression hearing. The trial court ended up retiring and then sadly passing away prior to the issuing of any opinion or anything of that nature, and there was a new trial court that issued findings of fact in the aftermath of that. And part of the problem is that the findings of fact do not specify a finding as to how quickly Mr. Foster was seen after.
Was there uncontroverted evidence from the officer about how long it took for him to get there?
He gave evidence on direct examination, Your Honor, that it would have been 10 to 15 seconds. However, also during direct examination, he described how the ShotSpotter system itself functions, and that it takes at least 30 to 45 seconds once the sound is heard for the sound to then get to a human person in some location in California.
Analyzes it to determine whether it is indeed gunshots that are heard, and then it gets transmitted to the police.
Correct, Your Honor. So we're talking about at least 30 to 45 seconds, plus at minimum the 10 to 15 seconds that Mr. Powers, or the Officer Powers, took to get to the scene. But I do want to clarify as well that on cross-examination, he also said that he could not be sure how long it took him to get there and that he'd have to look at his body-worn camera. That was the extent to the knowledge that we have as to how quick.
Counsel, can the shot spotter detect other loud noises like a car backfiring or a firecracker going off?
My understanding is that it can, Your Honor, though I will be candid with the court. That issue did not make it into the record for our particular case.
Isn't that the whole purpose of the human analysis of the shot spotter sounds before the information is conveyed to the police departments to determine, I mean, it may not be perfect, but to determine whether it could have been a car backfiring or fireworks rather than gunshots?
As I understand it, that is the purpose of that timing, Your Honor.
Counsel, is there any evidence in this case that shots were actually fired?
There was none introduced into the record, Your Honor.
So we don't actually know if shots were fired?
No, we don't.
But you didn't challenge that?
I did not challenge shot spotter's admissibility at the trial court, Your Honor.
Did you challenge its reliability?
I
Because otherwise, I don't know why we're here, to be honest with you.
understand that, Your Honor. From the very beginning, I have challenged the reliability of ShotSpotter rather than its admissibility.
But you challenged its admissibility because it didn't provide video evidence.
That's a part of it, Your Honor.
Well, what's
Yes.
the other part of it? Because that's the only part that I could discern from this.
So, Your Honor, there are several issues. First of all, there is no video evidence that ShotSpotter does. This is an audio-only system. And so it leaves
And
open.
therefore, it's unreliable, you say.
In part because of that, Your Honor, yes. So part of it is that there's no ability to give any sort of description as to potential suspects. The only thing that this thing is giving us is that there may be a gunshot in this one particular response area, but it gives...
That's a tremendous technological advantage, though, to the police to be able to get these reports rather than, relying on an individual in a house or on a corner calling the police. They're getting a report immediately.
Well, Your Honor, I'd argue that it's the exact same thing as another person who called, whether they're anonymous or whether they aren't. No matter what, if it's the same as if someone had called in Your Honor's scenario from a house and said, officers, I heard what I think are shots in the general vicinity of my house. But then they're not able to give a description as to who may have fired it, how many people there are, if there's any criminal activity going on, or whether it's even a gunshot. So all those things would be left to the imagination. And that's the exact same thing that ShotSpotter does. It leaves all of those things open.
But it summons police to investigate.
It does, Your Honor.
But in order to investigate, it has to be a reliable tip. Let's use that phraseology, correct?
Yes, Your Honor.
And if you challenge the reliability, then it's the Commonwealth's burden to establish that it is reliable. In 80% of the circumstances, shots have been fired. In 90% of the cases, shots have been fired. Isn't that how it's supposed to work under Commonwealth versus Brown?
I don't disagree with that, Your Honor. Again, I think there's a difference to be made here in my challenge. I did not, again, seek a Fry hearing in this case, which was a mistake on my part.
It's not a Fry hearing. I mean, they called an officer who was testifying. You challenge the reliability. The officer says, hey, we think it's reliable because when we respond, in 90% of the circumstances, we find that shots have been fired.
Yes,
and
Your
we're
Honor.
in a position to investigate on the spot based upon that information.
Well, I don't disagree with that, Your Honor, and the prosecution did not bring any of that sort of information to light.
But I thought, counsel, that these considerations are not the core of the issue, that the issue here is not reliability per se, or what we looked at in Whedon for that matter, but here the issue is whether the shot spotter alert without more provides reasonable suspicion as to this specific person.
Absolutely, Your Honor.
That's the issue.
And
Absolutely.
as much as we like that other issue and might want to address it, it's actually not before us, right?
I think that is fair enough, Your Honor, though I never want to leave a court's questions
How do
unanswered.
we decide if it's reasonable suspicion if we don't know whether or not it's reasonable to rely on spot shotter?
Well, that's the problem, Your Honor, because we can't.
Well, I mean, that's the crux of the issue, isn't it?
That's not what you argued.
No, what I argued here, Your Honor, is that the spatial and temporal proximity here is the issue that the lower courts relied heavily upon in making its determination. They more or less said shot spotter alert, fairly fast in time, and shot spotter is accurate so that when we arrive here, when the police arrive here, we're grabbing the first people we see. And I find that to be problematic because it doesn't give any additional information as to who specifically, as Justice Wecht was pointing out, may or may not be involved in this circumstance.
Well, the shots
Plus,
could have been fired from inside a house, right?
Absolutely, Your Honor. That was not. There's just nothing was brought into the record to suggest that it was fired at the particular exact spot where Mr. Foster was located. And to piggyback off of that, Your Honor, as far as the spatial proximity goes, this is problematic because as we have what we do have in the record, despite not having expert testimony and perhaps more information that we'd like in terms of how effective ShotSpotter is, and as Justice Donahue pointed out, it's effective in such and such amount of times, what we do know is that Officer Powers testified that at one point it's accurate to 80 to 100 feet. But then he said on direct and cross-examination that it's not always where they tell us that it is. And then he said this thing could be off by whole addresses. And then, even more than that, Your Honor, he states that when he was approaching the area at the intersection of Chateau Street and Hoffman Street, he says, I approached the intersection slowly because I didn't know if it was at the intersection or if it was at some particular residence on Hoffman Street.
Human beings also have this troublesome habit of moving around.
There's that as well, Your Honor. That's one thing that I found particularly problematic, and something that came to mind because Mr. Foster was originally seen in the vicinity of a vehicle. How on earth can the prosecution possibly say?
What they need is they need the ShotSpotter product to add a feature that has a huge loudspeaker that says, all criminals acting in this area freeze.
Absolutely, Your Honor. But to piggyback off of that point, the state of the law as it appears to exist right now is, instead of a loudspeaker, as Your Honor mentioned, saying all criminals freeze, more or less, this is everybody within our potential spatial response area is fair game for being seized here because there's no particularized suspicion to a particular individual. So in this particular circumstance, anybody who's within, for the way that I looked at it was, let's say a three address radius, anybody in that response area is fair game according to the prosecution's argument.
So we've talked about that before, the whole, mass shooting hysteria where everybody flees and the state police starts rounding everybody up and doing Terry stops of everybody.
Yes.
But that's not, we don't have that fact pattern here.
I agree with that.
We have a police officer testifying, I responded to the scene, and the only people we saw were these people in this car. So we don't have the parade of horribles that you're talking about. I guess the question is, and I'm focusing on the ShotSpotter thing, is it doesn't matter what the other possibilities were. Reasonable suspicion doesn't require police officers in the heat of the moment, to exclude the bullets coming from somewhere else. So focusing on what was the reasonable suspicion to light up this car by the police.
Well, Your Honor, that's part of our problem here.
Isn't that the whole problem? What was the reasonable suspicion the police had to light up this car?
Your Honor, as I see it, the only reasonable suspicion that they had was the ShotSpotter alert and the temporal and spatial proximity. That's it. But unfortunately, the lower courts also threw into the mix, first of all, that they gave this extra weight to ShotSpotter, saying with the ShotSpotter alert and these two people being the only people nearby, therefore they're fair game.
And also that they thought it was a high crime neighborhood, which I know Justice Wecht would like to opine on.
That's my understanding as well.
It's a high crime area, perhaps, that the 7 justices of this court could have been driving back from dinner in, and we could have had a flat tire and been pulled over there.
Absolutely,
right when the
Your Honor.
ShotSpotter alert happened.
Absolutely, Your Honor. That's our contention as well.
Did they identify the scene by where they found the car and your client? You said they arrived at the scene.
Yeah, they arrived at the address that I'm under the understanding of. From the record, they received word that this is 1439 Hoffman Street, and that is the place that they responded to.
Was the car specifically outside of that address?
It was on the alleyway, Your Honor, parked half on, half off, in that location.
So, counsel, is it the facts before us? ShotSpotter, officer travels. There's the element of the officer testifying to a high crime area, and there's an individual in a car getting out of the car. That is the alleged reasonable, articulable suspicion for the alleged investigatory detention.
It's part of that as well, Your Honor. There's one other thing as well. The lower courts and the prosecution have previously focused on the fact that Mr. Foster was, as they put it, evasive, and they likened that to the Ragland case, which I discussed.
That's after, though.
Right, that's the point.
The whole concept is, what I find interesting in this case is based upon the facts before us. The officer immediately said it's not a mere encounter, which is a consensual conversation. This had to be elevated to an investigatory detention, but that in and of itself requires reasonable suspicion.
I agree, Your Honor.
So that's the real issue.
Already lit it up, right?
Correct.
Yes,
And that's the question for the Commonwealth he has to convince us up here as to how that wasn't just a mere encounter and what elevated it to a reasonable suspicion, because nothing. Well, I'll leave that for the Commonwealth.
Well, Your Honor, I agree with that. I'll piggyback off that as well and say, I certainly have no problem with, police responding to some sort of alert. I don't have an issue with them going there and trying to suppress potential gun violence. I mean, yes, we have an epidemic of violence in this country. There's not an issue there. But this should have been a mere encounter if that's the only interaction that should have happened here. They based suspicion only on the temporal and proximity of the ShotSpotter alert, and they grabbed my client because he was the only person that they saw. And
Well, there was another individual in the car, correct?
There was, Your Honor. They did not focus on her at first. Mr. Foster was the person who was first seized.
Remind me what time of night this was?
Your Honor, the record, I believe, points to somewhere in the neighborhood of 2 in the morning. And one other point I think that is relevant to mention as far as the spatial response area is, this is not. There's been all kinds of talk about open fields this morning, but if ShotSpotter was out in farm country, and the addresses are separated by like 10, 15 football fields, maybe spatial response area becomes much more important. Maybe that's enough to give reasonable suspicion. But here, this is the Manchester neighborhood of the city of Pittsburgh. There's houses around here. There's at least four different houses that I know about that are in that one particular block. Forgetting
no elk at all,
and no elk, Justice Wecht, as that we know of. But if the elk had a gun, he may have been seized. I don't know. But that is really the sum and substance of that problem. And so when the spatial response area is this size, I just don't see how you can possibly base reasonable suspicion on one particular person. If this is the rule that we are going to exist under in the Commonwealth, then everybody within one ShotSpotter alert, however large the spatial response area is going to get stopped every time. And the way that the law exists now, that's permissible, that they can be grabbed that way.
Does it make any difference that this was essentially in the middle of the night?
I don't think it does, Your Honor. In preparing to be before Your Honors this morning, I received a question about whether, is this any different than if there was a crowd in the middle of the day? And I argue that it is no different because the prosecution didn't bring into the record that there were no other people around, or that the spatial response area is so small as to exclude all the people around. So it's the exact same thing. If this was in the middle of the day and there's 10 people around plus my client, again, how do we get reasonable suspicion that one of them is involved, forgetting, of course, the fact that Justice Weck pointed out that there may be elk passing by and that there may be a vehicle driving through and could have been gone by the time the police arrive.
Well, particularly since we don't know whether the shot spotter is identifying a shot in the street or inside a house. Individuals could be inside those 2 or 3 houses.
Absolutely, Your Honor.
Okay.
In the houses, in the garages, in the yards. I mean, it's also Pennsylvania. People have firearms, and maybe there's critters and things that people shoot at. Maybe it's a non-criminal event at all. Maybe they were cleaning their gun and it went off.
This is an urban area, correct?
It is, Your Honor. It's still an urban area, but I have, again,
I'm not sure it's legal to hunt elk in an urban area.
I'm
not sure it's practically an option, and I'm not sure it's legal either.
You'd probably shoot a groundhog. You could probably shoot a
I
groundhog.
don't think you can.
No?
It may be, Your Honor, I will say this, it may be a local ordinance, but as I understand it, there is no criminal code law that prevents it, even in an urban area. Yes, Your Honor.
I'm pretty sure.
Not nice.
I'm pretty sure there's setback requirements with regard to shooting at.
Yes.
It's not polite.
Well, that was our case.
Anything else for us?
Your Honor, if I just can have one moment.
Surely.
Thank you.
But you are ahead.
Thank you, Judge. Your Honor, in closing, I will just say, I think even that the Commonwealth can understand our position here, and I think that they've somewhat conceded to it in closing on page 27 of their brief. In sum, if we assume that the Superior Court found that the shot spotter was reliable enough to establish that there was gunshots in a particular area, they say then this, coupled with other factors, can be enough to establish reasonable suspicion. And that's our entire point here. It has to be coupled with other factors, supported by further investigation or corroboration. I'm asking that the court give us something in that neighborhood, some kind of rule in that neighborhood, in order to find reasonable suspicion before a particular individual, in this case Mr. Foster, was wrongfully seized. I thank you all for your time. It was a pleasure.
All right, thank you very much. Let's hear from Mr. Nepa.
Good afternoon, Your Honors. Francesco Nepa for the Allegheny County District Attorney's Office. If I could just real quickly focus in on the facts, just so we're on the same page. The officer got a shot spotter alert indicating that one shot had been fired at this particular address. When he was within a block or two of that address, he got a second alert saying that 4 more shots had been fired. Within 10 to 15 seconds of that, he's approaching the address and he can see the defendant and his companion in the car. They're the only people on the street. The defendant's companion is reaching for something in the front seat. The defendant, as the officer turns the car onto the street, gets out of the car and starts walking off in a different direction. These are the only 2 people on the street. So it is all of...
Can I just confirm with that? Because I thought he got out of the car after the police lit the car up.
Well, I mean, lit the car up. I mean, the officer put his lights on.
That's lighting the car.
There's no siren. He put his lights on as he...
I didn't say siren the car up. I said
I'm just trying to, get the facts.
He lit the car up and then he got out of the car. Isn't that an important distinction?
I don't know that. It seems sort of like a simultaneous. It seemed like a simultaneous action. I don't know. The record speaks for itself. Is that what we are considering the investigative detention? The moment that he.
Well, you agree that our law would basically say if the police officers engage their lights in front of somebody, that triggers an investigatory stop.
All I know is that the Superior Court, and they could be wrong, but the Superior...
Am I wrong on that, on the status of the law?
No, I guess I'm not disagreeing with you. It is nighttime and 5 shots have been fired. I mean...
Sounds that trigger an investigation to ascertain whether they've been shot, right?
Yeah, sure. But
so there's a good... Let's just assume, arguendo, that this is reliable, which I know is contested. But let's assume it's reliable. And let's assume it's a good investigation. And we were down this road, and were you counsel on?
I was.
Right, so we've been down this road with ShotSpotter. Let's assume it's a great investigative tool, which apparently the city or the DA's office is determined, unlike some other cities apparently. Okay, so now it's a good investigative tool and the officer reports to the scene. Do you maintain that is not merely an investigative lead, but trial evidence for reasonable suspicion?
Well, I am not saying that he could detain the defendant just on that, if that's if that's your question to me. I'm not saying that. I'm not saying that alone gives him the opportunity
It's also that
to
it's
stop.
Manchester, it's 2 a.m,
Let-
all the high crime stuff.
That is less significant than the fact that they were the only people on the street, the companion was reaching for things, and the actions of the defendant in getting out of the car.
Let me
and
just ask
going
one
out.
more follow-up, if I may, Mr. Kemp. Do you agree, or do you not agree, that the function here of the shot spotter technology as a tool for law enforcement is essentially the same as an anonymous tip? In other words, it sends an officer to investigate. Do you agree it's just a high-tech version of that?
No.
You don't?
No. Because with an anonymous tip, you have no idea, the police have no idea that the thing mentioned exists to any extent at all. They don't know who this person is who is saying the thing. In this case, ShotSpotter, the only thing they're telling the police is that shots have been detected, what ShotSpotter believes, shots that were detected in a particular area, in a particular location. So I don't see how that is the equivalent of an anonymous tip.
It's the equivalent of a known tipster.
Yeah,
Correct?
to some extent, yeah. I think that's fair.
Okay, well, but when you have a known tipster and the police are relying on it, they have to prove the reliability of that known tipster. I keep getting back to that point. We don't have that.
I agree with you that what you said earlier, that the reliability was not contested. I mean, if it were contested, this would be a different situation. It's never contested. It seems never contested. It's only contested on appeal. And in the amicus briefs, when
What about my hypothetical? So, a bit odd, but hypotheticals are. So the 7 of us are out to dinner, and there's a traffic jam on 65, so we divert through Manchester. Get a flat tire. There we are when this officer happens to report for the investigation. Is there something about us that's inherently less suspicious than Mr. Foster?
only the actions of leaving the car and walking away from the police officer. If you all were just sitting in the car and the officer comes up and maybe he would ask you a question or something like that, but when the detention, at least as the Superior Court found, is only when the defendant started walking away, and in conjunction with the actions of his companion, the officer said, "Stop, come back to the street."
Well, I'm confused.
That was
Your response earlier was you seem to put great weight on the idea that the companion was seen. Again, I'm not really sure how you could see at 3 o'clock in the morning what the companion is doing. But
well, the officer said that he turned his car onto the street and he could see right into the windshield.
he could see the companion. He could. Okay. But I guess now you're saying that no, the companion reaching was not the reasonable suspicion to do the stop, because the stop happened before he got out of the car.
Until I got here today, the reasonable suspicion, the stop occurred. All the parties agreed at the Superior Court level that the stop occurred when the officer told the defendant to come back to the street, and that's the premise that I'm operating on here today. That's the premise upon which I wrote the brief.
We should ignore. We should ignore any feelings that we have the stop might have occurred earlier and stick with the stipulated stop happening when he was ordered to come back to the car.
I don't know. I'm just telling.
I'm fine with that if that's what you want, but I mean.
I think you could. Like I said, if you read the Superior Court's opinion, the parties were in agreement that was the moment where the stop occurred, when the officer said, "Stop," and I don't know if he used the word stop, but come back to the street. That was the moment when the detention occurred, and that's the place that I am operating from. That's the investigative detention occurred at the moment at which the officer told the defendant to come back to the street.
But it became an investigative stop when he lit up his car lights, right?
That's not what was said. That's not what was said below.
That's what our case law says.
Is that not, they're the facts before this court. For example, if the officer was just driving in the neighborhood on routine patrol, he hears what he believes to be gunshots. He drives and sees the same incident. Does he have reasonable suspicion then?
Could you say that one more time? I'm sorry.
Exclude the shot spot.
Okay.
He's driving on a routine patrol at night. He hears what he believes to be gunshots. Drives 10, 13 seconds later, sees the parked car. Guy gets out and walks. Is that the reasonable suspicion?
It seems in that area, he heard them right there. I would think that would be reasonable suspicion to just. No, I just think it's reasonable suspicion to just conduct a brief stop to determine what the extent, if any, that this person was involved in criminal activity.
What I find interesting in the argument is the converse is you argue that it's a high crime area because it's an urban area that I would assume is a minority area. But that being said, this high crime area, so an individual at 2 o'clock in the morning who's sitting in the car with paramour or whomever, sees a car coming right quickly, pulling over. Doesn't it make sense that it's, we follow your theory that it's a high crime area, that the people in the car are concerned with their safety and they want to get away from the scenario?
Well, you say my theory of a high crime area. The high crime area is really not particularly. It might be a factor. It's not extremely relevant to me because once you have gunshots, it really doesn't matter whether the area is a high crime area or not, right? All it does is help support the fact that there were gunshots.
Right, but you need something more to support an alleged belief. Because they say, what's the old expression? Officers not supposed to shrug his shoulders and walk away from a hunch. You need more.
You need.
He has a hunch something's happening. What is the more? A man in a car at 2 in the morning? Or is it the man in a car getting out of the car because maybe he too heard gunshots and he was fearful for his safety?
It is the things I mentioned before, the 5 gunshots that he got reports as to, the fact that these are the only 2 people near the address that the shots were supposedly came from.
You could have knocked on the door where the address was and said, hello, is everybody okay in here?
You mean if he didn't see anybody on the street?
Why not go to the house in which you're telling us the shots are located, as opposed to 2 individuals in a vehicle?
Well, I think he could certainly knock on. Couldn't he knock on the door? Yeah.
Can I ask it a different way?
Yeah.
Is it reasonable to suspect that a person who had illegally fired a weapon,
Illegally, right?
fired a weapon, would stay on the scene and sit in a car? Is that reasonable? A reasonable belief?
I think that when he hears when he gets his shot spotter alert and he comes down the street, I don't know that at that moment he's conducting an investigative detention. He might have gone up to this car and asked them, hey, did you guys hear anything? But when the guy started walking away, if the guy doesn't walk away, I don't think we have an investigation.
Well, this is my concern.
Mm-hmm.
I don't want to be inconsistent.
Mm-hmm.
And if we're saying that shot spotter plus fleeing gives you reasonable suspicion to stop the fleeing person, I don't know if we can say shot spotter plus sitting equals reasonable suspicion. Because whether you're fleeing or sitting, it doesn't really matter then.
What do you mean it doesn't really matter? I tend to agree with you.
I can sort of actually agree with you in one respect, and I think it's consistent with some opinions that we've issued, is if police officers are responding to alleged shots, I'm not going to talk about shot spotter for a second, alleged spots, and they're responding, they're going into the area, and they see one person fleeing, that may be reasonable suspicion to stop that one person. Because 1, you had the shots. 2, there's only one person fleeing from the area that you can see. Reasonable suspicion to believe that person may have been involved in criminal activity. But I'm concerned in this case, if I vote to uphold the Superior Court, I'm saying the converse. Reports of shots fired, respond to the scene, only one person sitting in a vehicle, or 2 people sitting in a vehicle. Reasonable suspicion to talk to them.
No, because those aren't, I mean, at least like as I was saying earlier, as I understood the facts, that's not the scenario.
Okay, well, add the scenario, lights the car up, he gets out, or maybe he lights the car up after he gets out, but he gets out. Wasn't he entitled to leave? Does the Constitution give him the right at that point in time to get out of the vehicle and not cooperate with a mere encounter?
Well, how does that play into whether the officer, from his perspective, thinks there's a reasonable suspicion to believe that this person was involved?
That's
in
what I'm
criminal
asking
activity?
you. I'm trying to reconcile the sitting put versus fleeing paradigm.
If he's sitting in the car,
Right.
and the officer went up to him,
Right.
and said, "Hey, we heard a bunch of shots. Or you know anything about that?" And he said, "No, nothing."
He got up and left.
And then he left. Then perhaps not. But in this case,
Why isn't this situation the equivalent? The police car comes up, he gets up and leaves, meaning I'm not going to cooperate with whatever you're asking me. I don't want to talk to you. I'm going to get up and leave.
well, I think that would that be suspicious? I mean, I guess
That's sort of what you have.
would it depend to the officer if that was suspicious or not, based on his training?
But I think you're missing an interesting point that at least I'm taking away from part of what Justice Robson said, which is that it seems like under your argument, you would maintain that there's reasonable suspicion here, whatever Foster did, or whatever he didn't do. If he sits there, reasonable suspicion. If he gets up and walks away, reasonable suspicion. It seems awfully flexible.
But I didn't say that. I didn't say if he sat there that it would necessarily be
I thought
reasonable
you were emphasizing the importance of the girlfriend or the companion reaching for the glove box.
That's something?
while they sat.
That's something?
So if the officer walks up in that scenario, and now Foster has not gotten out, but it seems based upon your emphasis of the girlfriend reaching for the glove box, you would be telling us there's reasonable suspicion then too.
If he doesn't get out? Is that what you said?
Yeah.
Maybe, but I mean, that's not, you have more than that in this situation.
was
You
he-
don't have him sitting
Was he
there.
free to leave? Was he under detention yet when he started to walk away?
The Superior Court said no. The Superior Court said he was not until he was told that he
Well,
couldn't come.
how can that be a basis for reasonable suspicion if he was free to walk away? How can you hold somebody's choice of walking away as reasonable suspicion?
Or more so, share with us, if we follow your theory, you eviscerate this concept of a mere encounter. Is that what you're saying? That mere
I
encounter
didn't
is
think
no
that
longer-
was what I was saying.
Well, a mere encounter means do we not all know in criminal law, mere encounter, if a police officer comes up, you have the right to walk away?
Yes.
Okay, so what's the difference here?
Well, I think it's the combination of everything, right? Maybe if there were other people on the street, maybe if there was no action by his companion, maybe you would say, as you're right to, the fact that someone just starts walking calmly away from an officer turning on the street would not be reasonable suspicion.
Now it's how calmly he looked at 3 a.m. I mean, in other words, the point is, do you agree with the proposition of law that to be commanded to stop requires reasonable suspicion?
Yeah?
Okay, well, don't you see the problem in your argument?
No? No?
You can't have a right to walk away under the peril that your right to walk away will be used as reasonable suspicion to detain you. That's the point that I think Justice Wecht is asking. I don't know if he's asking that. I was trying to get to that. That's what I'm having a hard time reconciling here. I understand, again, the concept of an individual fleeing. One would expect if somebody's engaging in criminal activity, they're going to try to get away. They're not going to hang out.
Or if they heard gunshots and they want to run away from it.
Right. But we're going to the other side, which says, well, now you can stay, and there's reasonable suspicion because you stayed. But if you exercise your right to voluntarily leave on the basis of a mere encounter, we are now going to say we have reasonable suspicion because you exercised your right to voluntarily leave.
Well, look, there's a lot going on here, right? The officer here gets a report that there are 5 shots, right? There's 5 shots in this area. There are only these people. The reasonable suspicion standard isn't that high, right? Is it reasonable to think that these people
That's what I
had
asked
something
you.
to do with these
Is it
shootings?
reasonable to believe that someone who illegally fired a weapon would just sit in the car right where it was being fired?
Probably not.
What's reasonable is to continue the investigation. That's different from reasonable suspicion for constitutional purposes.
Well,
And just one more thing, in follow-up to Justice Brobson and Justice Wecht, he wasn't sitting in the car for a half hour. He was sitting in the car for maybe a minute or a minute and a half.
If that, I mean, the officer doesn't know because the officer just turned the corner, he was sitting, and then he left as the officer turned onto the street. So I guess he doesn't know.
I'm sorry, sitting after the officer got there. I guess we don't know how long he was sitting there.
But also add to the mix, there's no evidence that shots were fired.
Well, it depends, that shots were, you mean no, I'm sorry, no additional evidence.
Yes.
No additional evidence.
No additional
yeah.
evidence that shots were fired.
Right, that's
You didn't
correct.
have a body, you didn't have bullet casings.
That
you
is
had-
correct.
You had people sitting in a car?
You had people sitting in a car. I mean, if you had, somebody shot on the street, then you got an issue, I mean, and you have reasonable, if you have casings, bullet casings, I mean, but there was none of that either. And it sort of works against you to say they got there so quickly. If you get there so quickly and shots were fired, you think you would think that there would be evidence that shots were fired in that particular location. Doesn't mean there weren't shots fired in some house along the way, but
Well, let me say this. I don't know if there was evidence that there were shots fired or not. I don't know what, this was a drunk driving case. So I don't know if there was anything, I don't know if there's any other case involving the actual shots that were recorded by ShotSpotter. When they stopped this gentleman, he was under the influence of alcohol.
yeah, but that's not why they stopped them. They stopped them because
No, I
they
understand.
got a report.
Yeah, that's even more boost. That's bootstrapping.
That's even, I mean, they stopped him because they got a report of something that sounded like shots fired in that area.
Yes, what I'm saying to you is any further investigation of whether or not there were shots fired, it had nothing to do with this individual, so I don't know whether there ultimately were any shots, any further evidence of shots being fired.
We truly get this. Do you want to wrap up?
Yeah, I just wanted to respond to one thing Justice Wecht said about the further investigation. And that comes from the anonymous tip cases. And they say that the officers only have to do they do not have to do further investigation if there's already sufficient detail that confirms the tip. And I guess that's what we're discussing here. Was there already sufficient? We say there was. The Superior Court said there was already support for the fact that shots were fired by this guy's actions. Now, if you don't think that's good enough, you're the Supreme Court. But unless you have any other questions, I'll stop.
Always a pleasure.
Chief, can I just ask one question?
Yes.
I hope this doesn't open up a can of worms.
Okay, I hope not too.
Once he left the car, why didn't the police officer detain the woman in the car who engaged in the furtive movement?
I don't know what became of her case. I don't know. Multiple police
But her
officers.
furtive movement, you believe, helped to create reasonable suspicion for him?
I do.
Okay.
Yeah, I do.
Thank you.
Thank you.
Thank you both. Mr. Minner, would you call the next case?
Erie Insurance Exchange versus United Services Automobile Association versus Bates Collision. Representing the United Services, Ms. Patricia Monahan. Representing Bates Collision, Mr. Glenn Chicknow.
Good afternoon.
Good afternoon.
This matter involves a fire which occurred at an auto body shop and resulted in damage to the shop and several vehicles. Erie Insurance Exchange insured several of the damaged vehicles as well as the auto body shop. Believing that a BMW in the shop may have caused the fire, Erie asked the insurer, USAA, to secure and preserve the BMW for further investigation. Although USAA agreed to do so, a third party later sold the BMW at a salvage auction. As a result, Erie filed suit against USAA, raising a claim of promissory estoppel. Viewing Erie's claim as essentially one for negligent spoliation of evidence, which Pennsylvania does not recognize, the trial court granted summary judgment in favor of USAA. The Superior Court reversed. We granted allowance of appeal to determine whether an insurer has a cause of action for promissory estoppel in relation to the unintentional destruction of evidence. Further, if an insurer does have such a cause of action, we will address whether it may bring a claim for promissory estoppel in a subrogation action on behalf of its insured. It really sounds like I've just stated a bar exam question. And I'm sure you're going to give us the answers, so please proceed.
Hopefully. Thank you. Good afternoon, Chief Justice Todd and members of the court. As stated, my name is Patricia Monahan, and I represent United Services Automobile Association. And we're here today to discuss two issues that Superior Court did not discuss. And I know the court is familiar with the facts of this case, but I would like to say, in response to Chief Justice Todd's summary of the facts, it was stated that USAA promised to preserve the vehicle, and technically the letter that Erie Insurance relies upon states that USAA agreed to request that the vehicle be preserved. But in any case, I would like to start my argument by pointing out page 58 of Erie's brief. Erie's brief states that it was not required to identify any cause of action at all, and all they have to do is allege the material facts. USAA absolutely agrees with that, and that is what we have been saying since the trial court. We need to look at the facts to determine whether there is a cause of action that Pennsylvania recognizes for Erie Insurance to move forward with the cause of action against USAA. Our argument before the trial court, which was successful, is that based upon the Pennsylvania Supreme Court's public policy as expressed in the Pirates case, a cause of action is not recognized for negligent destruction of evidence, and it's not recognized because the damages are speculative. It's not the amount of the damages that are speculative, it's whether the party is entitled to damages whatsoever. So we agree with Erie. It doesn't need to be labeled any particular cause of action. Let's look at the facts. The facts of this case are indistinguishable from the facts in the Pirates case. In the Pirates case, the Commonwealth, or the state troopers had agreed over and above, and actually contrary to their guidelines, that they would keep and preserve a belt that the plaintiffs and Pirates wanted to use to prove a product's liability claim that unfortunately resulted in the death of the plaintiff and Pirates when the belt failed in a tree stand. 2 years later, when the family went back to the state troopers and said, "Where's that belt that you promised me?" Unfortunately, it had been destroyed and not on purpose, which is the same exact set of facts that we have in this case. So when we look at these facts, when Erie came back a little bit more than 2 months, I believe, and said, "We would like to engage in destructive testing of the vehicle," and it was accidentally gone, Erie brought the cause of action. And USAA said, based upon the Pirates case, it doesn't matter what you want to call your cause of action. You don't have to label it at anything. We agree with what Erie said in their brief. But Pennsylvania public policy has said when the fact of the damages are speculative, there's no recognized cause of action. And I'd like to discuss two cases that are brought up in our briefs that have been consistent in this case, and also reiterate the fact that Superior Court did not discuss Pennsylvania public policy. But it goes back to 1965. There is a case called Wilcox versus Register, which we have consistently cited, and that is a Pennsylvania Supreme Court case. It is 60 years old. 60 years ago, the Pennsylvania Supreme Court case said, and the Wilcox case was a contract claim, and that's another thing that Erie says in this case. We're not bringing a tort claim, it's a contract claim, so the damages are different. Well, guess what? The fact of the damages being speculative and public policy not recognizing that, Pennsylvania has said it doesn't matter whether it's a contract or a tort claim. It was a contract claim that was at issue in the Wilcox case. In the Wilcox case,
Spoliation, as recognized in some jurisdictions, always sounding in tort. I mean, those jurisdictions that have recognized the cause of action for spoliation as such, those all sound in tort, don't they?
I think some of the other cases, to be fair, in other jurisdictions may have insinuated maybe there could be a contract claim. The promissory estoppel claim that Erie came forward with, which they said on day one of their complaint, they were analogizing it to the Cooper case in California, which I think was a promissory estoppel case. But in any case, going back to the...
Before you move on, I mean, the Aplt case analyzed spoliation as a tort action. They started with, is there a duty?
Right.
So, I mean, they were looking at that potential cause of action as one in tort.
I think Erie acknowledges that they don't have a cause of action in tort.
You seem to be suggesting that it's not a tort action.
Well, it's...
And that is their argument. In contract actions, unlike in negligence actions, damages is an element of the cause of action. In contract actions, damages are not an element of a breach of contract action. And that's what their argument is. The problem they have is promissory estoppel is akin to a contract action, and it's not a contract action because it sounds inequity. But that's why they're making that argument. They don't have to prove damages in a contract action.
I think what we need to do, though, is look at the big picture. I mean, I think that in going back to your first question, I believe Erie acknowledges that they don't have a tort cause of action because the Supreme Court of Pennsylvania in Pirates has said no negligence spoliation. But to address your question on the contract, it's not that the damages have to be part of the cause of action as they would in a tort claim. It's the overall public policy. We can't go forward when the damages are speculative. And going back to the Wilcox case 60 years ago, that was a case where a liquor license was supposed to be transferred. It didn't get transferred. The person who wanted it to be transferred said, I lost all this money, I lost profits, because if you would have transferred that to me like you were supposed to under this contract, I would have earned all this money. The same reasoning by the Superior Court years later in the Logan versus Altoona-Muir case, where ads were supposed to be placed for a candidate who was running for office. And the candidate said, you didn't place those ads, I would have won. I want those damages, and those are contract damages. The Pennsylvania Supreme Court, or the Superior Court in Logan, following the Wilcox case, in contract cases said, our policy does not recognize this because the damages are speculative. And in this case, the damages are absolutely speculative. I know that Erie's other argument is fairness and equity, injustice, or it would be unjust if Erie cannot have this cause of action, even though we don't have the cars where they can prove the products manufacturing claim, products liability claim against BMW. But in the...
I'm sorry, North, but I can nail this down. Is it necessary for you to prevail? Is it necessary that we agree with you that spoliation, a spoliation theory must contain a promissory estoppel claim within it, or a breach of promise?
I think it's necessary for Erie to prove that. In order for USAA to prevail, I think the court has to agree with Erie. Doesn't matter what you label your cause of action, we're going to look at the facts. And in this particular case, are we going to allow Erie to come into court and ask the jury to award it damages for a products liability case that they can't prove?
Could I make a promise to you in the nature of a contract to retain something for you and then breach that contract? to be actionable under Pennsylvania law?
Under Pennsylvania law, it requires consideration, and it would be promissory estoppel if we don't have consideration.
Assume there's some consideration.
Okay. Well, assuming there's consideration, then it would be a breach of contract claim, and I think it would depend on whether the damages are speculative or not. What kind of cause of action what did you intend to bring? Did you intend to go open up your own business and you would have been the rich neighbor down the street? I would say no, because those damages are speculative, and Pennsylvania has disallowed those types of cause of action.
Still have a contract claim, though. You would have a difficulty when you got to the proof of damages, but you could have that contract claim.
But the cases that go back to Wilcox do say when it is the fact of damages that you can't prove, when those damages are speculative, that you don't have a cause of action. And that's where we are here. And I do want to address Erie's argument that the promise should be enforced because it's going to be unjust. Well, we have engaged in some discovery in this case, and the facts aren't as clear on a potential products liability claim as Erie would like to believe. I mean, yes, the fire started in the area of the BMW. Was that BMW subject to some type of recall? Absolutely not. The recall that Erie wants to talk about was on a different type of BMW, a different year, not this particular BMW. And guess what? The fire would have never happened if Bates Collision had properly repaired that vehicle. Bates Collision was supposed to de-energize that battery. It was not supposed to be plugged in on that Sunday afternoon when the fire started. If that vehicle had been depowered, we wouldn't be here because there never would have been a fire. Second of all, our experts have said that Bates Collision chose to use a recycled part, a recycled steering part in that BMW.
Matters, does it?
It only matters, and because I wanted to address their argument about injustice. And then another thing if
they're looking for justice, they're in the wrong place. I mean, we're just, at least in this case. I mean, this case is simply about whether our spoliation principles should apply in the context of a promissory estoppel claim. That's
right.
it.
But
right?
if I could
let the law be, affect whatever injustice it does.
Right.
That's what the law is.
Another argument that they have is they want the court to understand that this is how things happen in the subrogation world, and there's fire standards. The fire standards aren't the law. It may be the normal course. And apparently the normal course between parties goes pretty well because they've cited our own experts saying she's never heard of such a situation before. And just so the court understands, there were some cross-examination depositions in the underlying case. Did you open a subrogation claim? Did you do this? Did you follow your own subrogation standards? USAA and Erie were never on the same page in this investigation. Erie wrote a letter to our insured, the owner of that BMW, and put him on notice of a claim. So when USAA sent experts in initially to investigate this fire, it was to protect the insured. Should we have opened up a subrogation claim, and should we have considered suing BMW like they wanted to do? I don't know, but we were never going to do that, and that is not in the record. But to back up though, I really think the court needs to look at the big picture. It was disappointing that the Superior Court didn't even address this because we have the Pirates case and we want to talk about, and I argued the case before Superior Court, we want to talk about what is Pennsylvania public policy. Are we allowed to go to court and ask the jury to speculate to damages based upon 60-year-old case law? And we don't have artificial intelligence 6 years later or 60 years later that is going to tell us what would have happened if that vehicle hadn't been destroyed and we would have tested it and we could have gone forward. We're nowhere, we're in the same place that we were 60 years ago when the seller of that liquor license couldn't, or when the person who wanted to buy it couldn't prove what his damages were if he had gotten that liquor license, or if the candidate had won in the Altoona Muir case.
I'm just a little bit confused as to why and how this discovery is taking place. Erie is bringing this claim. It has to be based upon the proposition that they cannot prove their case because of the spoliation of evidence.
Right.
Is that correct or not? So why are you talking about the evidence isn't as clear and there's some evidence about a battery that shouldn't have been where it was? I mean, their entire claim is based upon the proposition that they can't prove their case because the evidence is gone, correct?
Correct. I only bring it up because I don't get rebuttal, and they're going to talk about how injustice.
I would have said the same thing to him.
They're going to talk about how this promise should be prevented to prevent injustice. That's the only reason I brought it up.
But what motivation did your client have to allow the car to be destroyed?
None.
In a
Like
spoliation case, there's this concept of we're going to let this potentially bad evidence against us go away.
That would be intent. This is a negligence claim.
Well, but even negligence, you get a negative inference of some sort. But I'm just saying, what possible motivation did USAA have to just engage in this inequity?
None. I mean, the people involved wanted to keep the car, but unfortunately, we didn't do what we were supposed to do to keep it. It's negligence. But is negligence the issue in their cause of action?
Well, you're saying negligence, you're assuming you had a duty.
No, no. I'm saying that it was an accident. Nobody did it on purpose. And then the second part of our argument, that we're here before the Pennsylvania Supreme Court, which is an unusual issue, is really the caption of the case. And we were successful on this before the trial court. Erie brings the cause of action as subrogation. So technically, the plaintiffs are the people who suffered property damage. Bates Collision, other individuals who had their cars burnt. USAA had a couple of their cars, I think, in Bates Collision as well. A subrogation cause of action against USAA does not exist. The subrogation would have been potentially against BMW, not USAA. And Erie has never tried to amend the complaint. We are years down the line in this lawsuit where we have subrogation, which infers that USAA would have to potentially reimburse Erie for all of this property damage when USAA didn't cause the fire. So we submit that if this court allows this cause of action to go forward, it would be overruling Pirates. It doesn't matter what the label of the cause of action is. We agree with Erie in that regard. But if we're going to overrule Pirates, then it's the case Erie versus USAA, and Erie is not the real party in interest. And then the damages, even if you could recognize something, wouldn't necessarily be the property damage that Erie had to pay to its insureds as a result of this fire.
Thank you.
Any other questions from Ms. Monahan?
Okay, thank you.
Thank you very much. Let's hear from Mr. Shiganoff, who's back to see us, right?
Back again, Your Honor.
Must have had a wonderful time yesterday.
Oh, Your Honor, there was time spent. I can represent that.
That was a very fair answer.
Thank you, Your Honor. May it please. Your Honor, it seems to me like depending on what side of the aisle I'm on, I have a very different opinion of the Superior Court. Sometimes they're brilliant, sometimes they're not so brilliant. So thank you, Your Honor. May it please the court, Glenn Shiganoff on behalf of Erie Insurance Exchange. And Your Honor, Justice Donahue, you sort of made my argument for me here. This is a contractual claim. Promissory estoppel is not a tort. Promissory estoppel is included in the restatement of contracts, not the restatement of torts. It is taught in contracts classes in law school, not in torts class. It has completely different elements that are divergent from any elements required for a negligence claim. This was and never is a negligence claim.
That's also not a contract claim.
Right.
It is rooted in contract, Your Honor. That's where promissory estoppel comes from. The point of promissory estoppel is to substitute the promise for the consideration necessary in order to create a valid contract. When injustice would have to be avoided in order to do so. So in this case, Your Honor, we have...
What's the injustice that's being avoided here?
The repeated representations and promises made to Erie that were disregarded and breached, that Erie relied on.
What's the injustice that arose from that?
Your Honor, as a result of the fire, Erie had to pay a significant amount of money. There was all experts retained by both appellant as well as ourselves and other parties that all pointed to the BMW as specifically the source of the fire. There was an initial investigation done. The BMW was the only vehicle in the entire warehouse that suffered fire damage. All the others suffered smoke damage. So everything pointed that the origin of the fire, and this is actually, the appellant's expert agrees to this, the origin of the fire was the BMW. It's for that reason Erie asked the BMW to be preserved. It's for that reason USA agreed that the BMW be preserved. This is consistent. This wasn't.
Well, is that the case? Ms.
What's the
Monahan says they
injustice?
agreed to attempt to have it preserved or to ask to have it preserved, not agreed to preserve it. Which was it?
So the promise, Your Honor, can be by action, conduct, or silence. Any of those is enough to trigger promissory estoppel. In Krauss versus Cyclops Industries, for example, there was just silence. It was a steel manufacturer that communicated unilaterally with a tool manufacturer. They sent 2 letters saying, "It is my understanding you're going to be using my steel only for your tools." Those letters were never even responded to, yet this court upheld promissory estoppel based on silence alone.
Okay, what is the injustice that's being corrected here?
I mean, Your Honor,
That would allow you to get relief. What's the injustice?
that they got rid of a vehicle that they promised
And what?
and we had to pay money that we cannot recoup at this point, Your Honor.
And you don't know that.
Well-
That's the speculative nature of it, because if you knew that, you'd be suing BMW.
Well, Your Honor, the reason we can't sue BMW is specifically because of their actions, and I'd like to talk about this.
Why? See, I think you're ignoring the elephant in the room here. You are suing for promissory estoppel instead of calling it negligent spoliation, because you can't prove your case against BMW. That's exactly what you'd be doing if you brought a spoliation case.
Well, Your Honor, the purpose of suing under promissory estoppel is because there's a contractual relationship created. And I understand the damages issue, and I think that's an important one to discuss. As Your Honor said, damages...
But that's the injustice that's being avoided. That has to be your argument. I mean, it's an injustice that we can't prove our case against BMW.
as a result of them breaching their contractual promise.
That's the spoliation case.
So, Your Honor, I'd like to talk in the damages portion specifically because you asked about it. The interesting thing with promissory estoppel is its flexibility. Damages are not an element, and the restatement of contracts allows for different remedies as long as promissory estoppel is properly pled. One of those remedies is actual damages and consequential damages, but that's not the only one. The other ones are specific performance, restitution, reimbursement of fees, and the catch-all, that's the last one in the restatement, any other remedy a fact finder deems permissible in order to remedy the injustice. So those are factual issues.
What do you want as a result of this case? Let's assume that you're correct. What would your claim for relief be in this promissory estoppel case?
I would ask for all of those remedies, and I presume appellant would ask for none, and that would be up to the fact finder to determine.
No, it wouldn't. I mean, I guess I keep getting back to this point. I mean, your entire claim is premised on the fact that you can't sue BMW.
That's correct, Your Honor.
Well, and you have no reason to believe, as we sit here today, that you would prevail in that case against BMW. There's no value to be able to bring a lawsuit. The value is to recover your losses in that lawsuit, which you can't do.
Because of their actions, Your Honor.
Yeah, but see, that's what spoliation is. I mean, if you're correct, there's no need to have pirates. I mean, it essentially takes that case off of the books because everyone could then just plead promissory estoppel.
There would actually be two different causes of action, Your Honor. Pirates wouldn't have a promissory estoppel claim. It wouldn't survive.
But if what you're claiming is the same relief that's precluded because of the public policy of this Commonwealth, that you can't recover speculative damages, it doesn't matter what you call it. It doesn't matter if you call it promissory estoppel or if you call it negligent spoliation. Tell me why that's wrong.
Because the public policy analysis pertains to tort only. In a contractual case, the duty stems from the contract.
This isn't a contract case. This is a promissory estoppel case.
So-
If you had consideration here, you would have duty, breach of duty, and then you'd have to prove damages. I don't know how you prove it, but I mean, you'd be able to state a cause of action for breach of contract, and you know, you wouldn't be thrown out of court. You'd be able to prove that you had, you know, offered consideration for them to do what they didn't do, and so they breached. You'd still have to prove damages, but you'd still state your cause of action for breach of contract. But even in a contract case, you'd have to prove some kind of damages.
That's correct, Your Honor, and I would ask for one of those 5 or all of those 5 remedies.
Contract action, you wouldn't. You would prove damages. That's an action at law. You're not going to get restitution.
But in a promissory estoppel case, you would. That's under the restatement. So that's my entire point. I would ask that the trial court give that jury instruction to the fact finder. I would argue for recovery of all of those 5 elements and remedies. They would most likely argue for none, and I'd ask the fact finder to make that determination. The Pirates' decision and its policy factors simply don't make sense in a context. We can call it a contractual context, equitable recovery that is rooted in contract.
Let's assume you're right on that. How do you get around the standing problem?
Your Honor, it's a strange argument that USA makes on standing for me here, because Erie's entire interest in this case has always been as a subrogate. What I mean by that is Erie doesn't own Bates. Erie doesn't own any of these vehicles. The only interest it ever had in this property is because it was responsible for payment for this damage and became a subrogate once it became responsible for that
But if
payment.
it's a promissory estoppel claim, it's Erie's. It's not the insured's.
And Your Honor, it's pled as Erie ASO in the caption. And what I mean by that is, at the time the claim, the promise was received, it was received by Erie while acting as a subrogate. Erie was acting as a subrogate from day one. That was the only reason they were doing the fire investigation. That was the only reason they retained experts. That was the only reason they had any sort of communication with USAA. So it's a unique factual pattern in that.
But I'm sorry, I think I understand the origin of your interest in a case, obviously, but how can you? I mean, you can't sue to enforce rights of theirs that are when they're if they exist, they're your rights. Like you have to sue in subrogation or not. Didn't you pick the wrong horse to ride on here?
Well, Your Honor, the interesting thing with subrogation, it's a legal fiction. It's not limited to torts. It could be tort, contract, or any other type of cause of action that you stand in your insured shoes and be able to make a cause of action on. So what that means is, at the time that Erie received the promise, it was acting as a subrogate. Whether that promise was given to Erie as the subrogate or it goes to Bates Collision, comes back to Erie, it doesn't matter. We still end up at the same place. So those letters ASO at the end of the caption don't change the analysis here. Erie was always as a subrogate from day one. They have no other interest in this claim or in this fire.
So the insureds could have sued. Are you saying the insureds could have sued USAA?
If Erie recovered this promise on behalf of the insureds, they could have done so. Now, we have a subrogation right under both common law and the policy, so because Erie had to make the payment, they immediately get those rights from Bates Collision.
Mr. Shiganoff, you answered a question a minute ago about how you would go about proving damages, and you said through a variety of means.
Mm-hmm.
Could you be more specific? How precisely would you have proven damages?
So, Your Honor, the question before the court is obviously procedural, but let's say we get to the fact finder.
Yes.
There would be conflicting or appellant's counsel would have their own jury verdict, instructions or proposals. We would have ours. And what I would say is I would go through the history, and I'm not trial counsel in all candor to the court, but what I would do is go through the history of this contractual promise. So all of the elements of promissory estoppel and everything that, was
To establish the cause of action.
to establish the cause of action.
How would you demonstrate damages?
I would then demonstrate what Erie had to pay. I would demonstrate that all of the experts, including USA's representatives and experts, confirmed that the fire originated from the BMW. I would establish industry standards as well as their own standards that required them to preserve this BMW. They failed to do. And then I would say that based on that contractual breach is why we would get the remedy. And which remedy that is, we don't know. I would ask for, again, all 5. But this is something in the dissenting opinion that Judge Olson gets wrong, and I have tremendous respect for Judge Olson. I've argued in front of her many times. I feel even slightly bad saying this, but she conflates the two issues. She says at the very end of the dissent, the last paragraph, what if the jury says that the ultimate award is 0? And when I read that, I'm jumping out of my skin to say, then let the jury decide that. We don't know which remedy they're going to fashion. This isn't our summary judgment motion, it's theirs. We're just asking to proceed before a fact finder.
Well, the question in that regard would be, how do they do that? Like, what's the evidentiary value of this unknown thing?
Well, Your Honor, they're going to see how much Erie paid. That's down to the cent. They're going to see all the expenses Erie incurred for the fire. So getting the experts, conducting fire investigation, getting trial counsel. Those are all experts. That's actually one of the remedies available. They're going to see those numbers down to the cent. They're going to see any costs or expenses down to the cent. We're certainly going to argue all of those are covered, and then we're going to ask the trial judge to provide specific jury instructions about that last catch-all remedy. That last catch-all is very broad. You can review the restatement of contracts. It says any other remedy to avoid injustice. And that is going to be up to the fact finder. They may ultimately determine that they don't want to go with that catch-all. They may want to reimburse Erie for just expenses, half of the damages, something. But again, that's up to the fact finder. I can't.
Can I ask a question about the injustice, going back to Justice Donohue's point? The promissory estoppel exists as a cause of action to where you don't have a contract, but to not recognize it would affect an injustice, right?
Correct.
Can you just confirm for me that your client was without any power or ability to preserve this vehicle?
Yes, Your Honor. The reason for that is Erie doesn't own the vehicle. It would actually be stealing to basically just take it off the area of the lot where the fire occurred. So this is why in the
There's no way for you to get some sort of a court order or pay somebody else to pay you reach out individually to the place that Erie had arranged for the vehicle to be and say, we're paying you to preserve the vehicle. You had no ability to do anything like that.
So it's a great question, Your Honor. There were actually no storage fees, and that's in the record. So USA asking for storage fees, those were zero. The traditional subrogation industry functions by requiring, and this is within their guidelines, this is within the industry guidelines nationally, it requires the insurer who insured the vehicle to obtain it. And there's a reason for that, Your Honor. The National Fire Incident Association, that's public record, that's in our brief, recorded that Pennsylvania had 767,000 fire incidents in 2023. At the time of briefing, 2024 numbers weren't available. I'll represent to the court, ask the court to take judicial notice that it was 569,000 last year. So that's 1.5 million fire incidents over the last 2 years. The reason the subrogation industry has to rely on these types of assurances, and appellant suggests that, this is something Your Honor brought up that appellant suggests, the alternative would be to have to make 1.5 million dockets to file emergency motions overnight to make sure evidence is preserved. That's 1.5 million dockets that we were going to have to deal with insurers, but also non-insurers, anyone who really wants to preserve evidence, that's going to have to file on an emergency basis, get attorneys overnight, just to preserve evidence. It would wreck the subrogation industry. There's a reason the industry doesn't function in this way. There's a reason.
Special role for the subrogation industry? Is that what we're talking about here?
No, Your Honor. It's simply upholding a contract. I know Your Honor doesn't want to refer to it as a contractual claim. Quasi-contractual claim. We can agree on that term, Your Honor. The reason this is necessary is because while appellant in their brief repeatedly cites concerns with proliferation of litigation, the validity of a promissory estoppel claim in a subrogation action is the only thing that prevents proliferation of litigation. If these letters, if these representations, if these investigations are meaningless, when their own expert says in 25 years she's never seen an insurance company do this, she's never seen a vehicle not preserved, their own expert says this. She's aware of how the industry works. If these assurances no longer matter, then we're filing 1.5 million new dockets on emergencies each and every time we want to retain evidence just to investigate it. And the only other alternative, and Justice Robson's no longer here, but I know it was his question, but I'd like to keep going on this point. The only other alternative that the appellant proposes is the idea that, you can buy the evidence. So let's extrapolate that a bit. On the night of the fire, during the 1.5 million fires over the last 2 years, any party, whether insurance company or otherwise, that wants to merely preserve evidence to investigate it has to locate the owner, bargain with them, and apparently pony up money just for the chance to preserve the evidence. So a car might be worth $5,000, $10,000. A house might be worth $500,000. What their suggestion is that when a house has water damage, and I'm just using fire incident numbers, subrogation is much broader than that. Water damage for houses happens all the time. What they're suggesting is that every time a house has water damage, is about to collapse, in order to make sure it's not bulldozed the next day, you have to buy the house? That's absurd. That is an absurd result, and it should be treated as such. There's a reason that the subrogation industry has to function this way, but more importantly, Your Honors, I point Your Honors to the...
So it's only only a subrogation industry problem that we're dealing with here?
This would apply to any individual that would like to preserve. This doesn't have to be an insurance company.
What? How about the individual in Pirates?
The individual in Pirates never made
They had a promise that the evidence was going to be preserved.
They never proceeded in the promissory estoppel claim. There was no contraction.
But see, if you're right, then I'll just go back to what I said earlier. We are sub rosa reinstituting negligent spoliation.
It's not a negligence claim, Your Honor. That's the difference.
But if at the end, it doesn't matter if at the end of the day you can recover speculative damages. The whole notion that you could claim your cost of experts fees, if you lost the claim against BMW, your company would eat those experts fees.
BMW theoretically would.
But see, that's the problem. I mean, unless, and that gets you back to the reason that we don't recognize negligent spoliation. It's speculative as to whether or not there are damages. Whether you agree with that conclusion or not, and you're not asking us to revisit negligent spoliation.
I am not, Your Honor. Pirates has correctly decided.
The entire basis of that is a recognition of the fact that in order to not proliferate litigation, we are not going to allow a claim that at the end of the day is based upon speculative damages.
Well, Your Honor, and my whole point on this is that the remedies are wide and available, and it's up to the fact finder to determine whether there was in fact enough evidence to make these damages or a portion of these damages or none. But we're at the procedural stage here. The question before the court is simply procedurally, was a viable claim pled? And that's where Pirates differs here. Pirates is a tort claim. It says the word tort 26 times. Your Honor, Chief Justice Todd, you author a concurring opinion where you say, for purposes of this question in tort, I agree. There's a reason for...
How many times did I use the word tort?
Once, but it was one paragraph only, Your Honor, so I don't think you had a big chance there. And Your Honor, the reality here is those your policy factors simply don't apply. This idea that Pirates could have succeeded on this claim, well, they never pled the contractual claim. And there's one thing, and if I could ask this court to review one portion of Pirates, I would ask this court...
We'll look at the whole thing over and over.
If there's one to zero in on, Your Honor, I'd ask her to look at footnote 2. That is dispositive in this case in and of itself because it actually rejects appellant's claim. In footnote 2, this court said there was a single sentence pled in the complaint in Pirates that was an implied bailment. That's what it said. There was an implied bailment, and the theory behind implied bailment is I gave you property with the intent to get it back. You didn't give it back to me. There's a quasi-contractual relationship. And what this court said in footnote 2 is had the plaintiff proceeded on this claim, they would have entertained it. And they would have entertained it because it's contractual, it's not negligence, it's not spoliation. This whole case has nothing...
Bailment is strict liability.
That's correct, Your Honor.
That's a different concept that you're interjecting into this.
But it's an
promissory estoppel is not a strict liability claim.
Quasi-contractual.
It's not a strict liability.
It is not a strict liability, Your Honor. But that, and regardless of what the cause of action is, this court said that they would have entertained it had the plaintiff pursued it. The plaintiff simply didn't. They said it's a spoliation claim from day one. And Justice Eakin authors a concurring opinion on this very issue. He actually splits the two. Says this bailment issue is not a tort, it is not a negligent spoliation claim, and he was willing to entertain it. But he said under the facts of Pirates, the Commonwealth cannot be bound by an agent's representations when they're contrary to their internal guidelines. The trooper made a promise that was contrary to the internal guidelines, and so Justice Eakin explains that for that reason, the bailment claim can't go forward. Not only do we not have a Commonwealth entity here, but we actually have guidelines that mandated that the appellant retrain this type of evidence. They just didn't. They broke their own guidelines. They broke industry standards. They're well aware of this. And yet they're trying to come up with this technicality to apply Pirates that's a tort claim in a negligent context. Something I think it's important, I give my counsel credit on this. She actually conceded this during the oral argument and at page 18 of her reply brief. Each and every jurisdiction that has ever reviewed this has agreed with Erie. Each and every one. California has a whole body of law on this. Georgia Court of Appeals in Phillips versus Owners Insurance explicitly rejected the spoliation claim because the promissory estoppel claim was allowed to go forward. Washington, D.C. does this. Florida does this. This is all in our brief. And I encourage the clerks of this court to review it, maybe double check me. There is not a single case that has ever agreed with appellant on this issue. And each and every one of those cases was in the subrogation context. Each and every one of those cases was a vehicle or a tire or some vehicle part that was disposed of by an insurance company even though there was a contractual, quasi-contractual, sorry, Your Honor, I will keep referring to it that way from now on, quasi-contractual relationship with an insurance company. So the only argument they make against this in briefing is, well, those are persuasive cases. And of course it's persuasive authority. This court is now bound by them. But I'd just like to ask the court, is it possible that each and every jurisdiction was wrong on this issue, under these identical facts? Is it possible? There's a reason this is a valid claim. There's a reason that these assurances matter in the subrogation industry and otherwise. If we were denied this claim, we'll need a new court of common pleas, because there'll be 1.5 million new dockets every couple of years on an emergency basis.
I think we get it.
Can I ask one more question?
Sure.
Outside of the subrogation industry, when would this come up?
Anytime any party wants to retain
When would that
evidence.
be?
I would like someone to keep a piece of evidence for me in case I need it in the future. I have a contract with them, or I make them a promise that I justifiably relied on. They don't do that. I have no cause of action because I don't have a dollar of consideration.
And that's what happened in Pirates also, right?
Well, there was no promissory estoppel claim in Pirates.
But the situation you just described was what happened there.
Except he contradicted his own internal guidelines that made the promise invalid.
Thank you.
Thank you. It's a very interesting case, and of course, we'll take a close look at it. Thank you both.
Thank you, Your Honor.
You had more fun today than yesterday.
I did have more fun today. You see, it's this seat. I need this seat more. So, thank you, Your Honors. I appreciate it.
Thank you both.
That's the lesson. Always better to be an appellee.
Commonwealth of Pennsylvania versus Vincent Smith. Representing Mr. Smith, Mr. Corey Woods. Representing Commonwealth, Mr. Francesco Nepa.
After setting fire, another fire here, after setting fire to a residence in which 4 police officers were present, appellant pled guilty to 4 counts of arson endangering persons, or AEP, and the trial court sentenced him to 4 consecutive terms of incarceration. On appeal, appellant argued that he should only be sentenced on 1 count of AEP because he only started 1 fire. An en banc panel of the Superior Court affirmed appellant's sentence, concluding that the unit of prosecution for AEP is the commission of an arson, coupled with the act of recklessly endangering another person, such that separate sentences for each victim were permissible. We granted review to consider whether the unit of prosecution for AEP is each arson or each endangered person. Please proceed.
Thank you, Chief Justice Todd, Justices of the Court. Corey Woods here today on behalf of Mr. Smith. In the Satterfield case and in the Davidson case from 2009, this court identified that the unit of prosecution is the actus reus, the minimum conduct, Davidson said, key element of an offense that gives rise to criminal liability.
Isn't the actus reus here that the General Assembly was addressing the endangerment of the person by the fire, not the fact of the fire itself?
No. So let's jump right into the language itself. It's kind of attractive at first blush. If you grab sort of your chalk and try to remember
diagramming sentences in elementary school to say there are 3 clauses. There is a person commits a felony of the first degree if, clause 1. He intentionally starts a fire, does a couple other things, clause 2, and if he thereby endangers another person. It's easy to view that as this is one thing that he does, and this is 2 things that he does. And if we were from Saturn and we didn't understand what these words meant grammatically, that's absolutely, a reasonable construction. However, the word thereby is a word of causation. When you try to apply this statute in reality, there's nothing else that he does to thereby endanger somebody. He lights a fire, and the fire has an effect, thereby endangering somebody.
What about if he's driving drunk and he hits a car and kills 3 people? Homicide by vehicle, is he charged with 1? Is he, is 1 injury or death attributed to him, or all 3?
Yeah, I'll be frank, I haven't looked directly at the language of that statute, but what I can say is when you look at the language of the reckless endangerment statute, it's exactly the opposite. So instead of this thereby language of causation, as President Judge Lazarus said below, there is the language that's used in the reckless endangerment statute is conduct which endangers or may endanger. So here, the act of starting a fire causes endangerment. In the reckless endangerment statute, the conduct is defined by its endangerment. So the act itself is conduct which endangers.
Well, the conduct here, if it's starting a fire, that's not a criminal act. I can start a fire.
That's true, and the Commonwealth has done a good job of saying, well, we like to have the idea that something that is an actus reus is an evil act. Blackstone says, right? But there's a lot of statutes where the actus reus is not, inherently evil or dangerous or scary. For example, I cited one in the reply brief that includes using a computer or computer network as a e-crime. So there even murder, right? The actus reus of murder is killing. We have a death penalty. There are wars. There's self-defense. There's officers in the line of duty. The big picture that I want the court to look at here is the opinion below, and I think the opinion of the trial court kind of blends 2 concepts. What is the actus reus, the minimum conduct, the minimum act, the key element, versus what are the minimum elements that are necessary to establish liability?
I just, going back to my phrase that I can start a fire and that's not criminal, I'm just looking from some language from Satterfield, and it says the unit of prosecution is the actus reus that the General Assembly intended to punish. So the General Assembly did not, in this case, intend to punish somebody who started a fire. Their intent, I assume, was to punish somebody who started a fire that endangered another person.
So I think the key word there is it's the act the General Assembly intended to punish. And Justice Donoghue, in the opinion, goes at a later portion of the opinion and says something to the effect of the act is the same regardless of how many other persons are injured or not. And I think that's really important because we're focused on the element of the act. We're focused on the conduct. And this is really in effect because what he's done, his conduct, is to light a fire. It's true that fire then endangers somebody.
It depends if you're leaving an accident where there's 5 people that was injured, because that's leaving one accident, whereas in this, the actus reus is starting a fire that endangers another person.
Well, no, that would be true if we were under reckless endangerment. A fire which endangers would fit conduct which endangers under the reckless endangerment statute. That defines the act by reference to its effect. What's going on in the arsons endangering persons statute, and this is what Judge Pellegrini, I think, picked up on below. He said the act thereby endangers. So there's no additional act that is endangering. If this statute said,
What is the difference between conduct which endangers and act thereby endangers?
because thereby is a word of causation. It's just functionally.
Which is not a word of causation?
No, it is a word that, and
You can go back to grammar school because which and thereby, in my view, can be synonyms.
well, I understand that, but they're not. I get it. No, look, I actually spent some time, like, no, here's why. Here's
One's
why.
a consequence and one's a cause.
Right, one is language that is used to denote causation. And I was looking at English textbooks to try to figure this out. But one is a word that is used to evince causation. I cited a bunch of definitions for thereby in the brief. The other one, which, it's a operation word that defines preceding words. So if the statute said to Justice...
follows that.
No. So thereby is, let me give you just a very simple example. Johnny failed the test because he skipped class and thereby missed all the lessons. Johnny only failed the test because his only act was to miss class.
Where's the which?
Well, there's no which there. There's a thereby. So that's...
Okay, just the thereby.
Right.
Now the which.
So, there's no separate thing that Johnny has done that is, he also missed the lessons. It's bound up. It's an effect of missing class. Now, if we said Johnny failed the class because he engaged in conduct which the teacher found objectionable, we've now defined conduct, which is what REAP does, by resort to its further characteristics. Does that make sense? Like, there's a difference between...
Being honest, Mr. Woods, I'm not following you.
So it's just a difference of the definition of these prepositions.
I feel like the students in the cave with Plato.
I mean, you're just, it's, and I'm struggling a little bit because, I mean, you're suggesting that the General Assembly had Greg's reference manual and was parsing thereby and which, and I still go back to Justice Mundy's point, which is you set a fire that endangered somebody. Whether it was your conduct that endangered or the fire endangered, you set the fire that endangered somebody. That's the crime.
That's not what the words are. The words are not, I set a fire which endangered somebody or that endangered somebody. Those prepositions, which and that, would identify the fire by its further characteristics and your conduct by its further characteristics. When you say you set a fire and thereby endangered, grammatically, we're not defining the fire by... Well, we're identifying the results of the fire. So just like...
I think I'm with you. You throw me off there. Okay.
He started a fire, the fire endangered somebody. That's different than I engaged in non-specific conduct which endangered somebody. And that's the point that President Judge Lazarus identified.
Now you confuse me. What is your argument?
The actus reus of this crime is starting a fire. The element of and thereby endangers is a result of that actus reus. Just like in murder or in other statutes.
It's a related offense as captioned in
Precisely.
the statute.
Precisely.
You need the actus reus of an intentionally setting in a fire, and the related offense is either it's reckless conduct or inhabited building.
Right, and that's the next point I want to get to. So I see, Justice Robson, I see your point that, we don't necessarily have to get Greg's manual out and say that which
But I think I understand your argument now. You're saying the statute, when it references the harm to individuals, is the fire harming individuals, not him harming individuals.
Right, logically that's what is happening. And because we have to interpret these terms in context, I want to just walk through a little bit of why that makes a lot of sense, why the intentional starting of a fire is the key element here, because when you look through the rest of the statute, this key is opening up a lot of locks, right?
Could stop.
That was Judge Pellegrini's point in the three-judge panel.
Precisely.
Very, very simple. I mean, if you look at this, the statute, arson and related offenses, the actus reus is setting the fire. The rest of what happens in each of this section designates the grading of the felony that's committed. So if you look at arson endangering persons, which is, we can use here because there appears to be some ambiguity. So what this does is it identifies a felony of the first degree. If you look to, and it uses the same phraseology, and if one, he thereby recklessly endangers. If you look at arson endangering property, a felony of the second degree uses the same phraseology, and if he commits the act with intent of destroying, damaging, et cetera, et cetera. And if you go through the rest of the statutes, the same phraseology is used really to describe the grading of the felony that's involved.
Precisely. That's absolutely correct, Justice Thomas. Well, right, but it's helpful, even if it's ambiguous and they're potentially interchangeable. I'm sorry, Chief Justice, please.
No, please.
Well, I think there's two related points that kind of underline what Judge Pellegrini was driving at, and he didn't get to it because he found the language plain. But there's 2 points. Number one, that's not the kind of language that we use over in the Crimes Against Persons chapter. I'm sorry, in the article, or the assault chapter, or reckless endangerment statute. We don't use that language. That key's not opening up several locks. But the second point is, and we've cited this in the brief, we have the article from Professor Toll, and we have the fourth statement from Senator Hill, and they're talking about what the point of this sort of arson reform was. And the idea, before this statute was passed, it was basically common law arson still existed. There were a bunch of kind of disparate statutes. They said, if you burn a chicken coop, it's like 20 years. If you burn down a cruise liner, it's 2 years. It was very strange. It was all over the board because it just aggregated over time because of sort of legislative thoughts of the day. But the point of this statute is to say we're going to take all these kind of ad hoc statutes and we're going to consolidate them. We're going to say here are the different kind of harms that we're worried about.
In order to grade them.
In order to grade them.
Okay, could I just stop you there? If we accept your analysis, does that mean that an individual who goes to a nursing home and sets a fire that kills 100 people is going to have the exact same penalty as someone who goes to a building with just a security guard working and kills one person?
The short answer is no, and it's a great question. It's also one we got on the en banc panel from Judge Olson, because first of all, that person is guilty of X counts of murder if they die, or rape. So and the Commonwealth didn't charge rape in this case, so
but it could have.
It certainly could have.
The answer really is yes. You're getting the one count of arson, but you're going to if you want to punish the person, you'll get consecutive sentences of the recklessly endangering or the subsequent offense.
Right, and the reason is that this particular statute is designed to punish the arson as such, whereas this other statute is designed to protect.
The REAP is considering the injured.
Right. That's precisely right.
Thank you.
Which includes the very breadth of the persons endangered in this definition of the section we're looking at, because it includes any firefighter who appears at the scene. I mean, that's to indicate that is a person who is endangered, which would up this to a first-degree felony.
Right, and just to clarify the facts very briefly, the facts are not that Mr. Smith was in a house with 4 police officers and set it on fire. There was an altercation with some individuals, and I think that what happened was he thought, gee, I'm here with some deceased people, and I'm done, and he tries to burn himself to death in the house. And police come in, and that's fine, they should do that, but it's the point is, the harm to those folks is accounted for as persons in the chapter, article, etc., that deal with crimes against persons. This statute is focused on the harms that are caused by just lighting a fire.
Can I ask you a question? How does one, or what is your argument with regard to individual goes into a home and he starts setting a fire in the front room and a fire in the kitchen, and then there's 5 bedrooms and he starts a fire in between? Are we counting them as one arson or each separate act?
You know, it's interesting. I think if you start 3 fires and they happen to converge, you've started 3 fires.
This guy flipped 2 matches. Is that 2 acts of?
You know, I don't know. But I don't think it's just not been raised so far. But I think that's an interesting question. I think there are further questions to kind of stay up and talk about, and I'd love to do it, about right. This is Summers versus Tice. This is like joint.
We'll leave.
I don't know.
I'll leave the light on for us, right?
That's why we scheduled you for last.
I appreciate it. We can talk about like joint and several liability, and someone's got a match, and something. But the point is, this is about how many arsons. Maybe we can talk about how many arsons it is, but this is about the arson itself. I want to touch very briefly on some what I think are kind of odd consequences of a contrary approach. So, Justice Donahue, you mentioned arson endangering property, and there are other statutes, reckless burning or careless burning. I'll take that. Let's say we're talking about someone's hunting cabin. The consequence that comes from this interpretation that we're going to have each endangerment of persons or property is that if there's nothing in that cabin but a deck of cards, you've got 52 counts. You've got to count for every piece of chattel, right? That seems very odd. If you burn down a house, like you can see it. Every piece of personal property that is endangered is another first degree or second degree felony. That's an odd consequence, and I find myself thinking, just reflective of your concurring opinion in Peck, that says, we should really disabuse ourselves of the idea that just because some interpretation of a statute isn't maximally punitive, that's absurd or that's unreasonable. And in fact, we're supposed to cut the other way. And I'm burying the lead here a little bit because I feel really lucky today that I don't have to be right. I don't have to be correct about what the statute means. All I have to do is present a reasonable interpretation of the statute. I'm lucky that Judge Pellegrini already presented this interpretation of the statute. I think he's a reasonable guy. I think President Judge Lazarus is a reasonable jurist as well. Even if I'm wrong, if I'm reasonable, I'm okay. I think the one argument that the Commonwealth has consistently made here is the Frisbee case. And the Commonwealth is citing the Frisbee case for the idea that anytime the legislature uses the words of another, this somehow transforms the analysis per se. It always means a per person, per victim, per object actus reus. I just think that's a really bold view, because we don't do statutory interpretation like that. We look at something in context. We look at the text, the context, the history, the consequences, the purpose, and I don't think that carries a lot of water. So if there are no more questions, I'll just close by saying this: there is a thought or a feeling sometimes when we're interpreting criminal statutes that that we're giving a break to someone who, in this case, truly is someone who he pled guilty. He's avowedly committed criminal conduct. The rule of lenity is not a gift. It is not a break. The rule of lenity does really important constitutional work. It says if the legislature wants to criminalize something, if the executive branch wants to take someone's liberty away for violating the law, it had better have clear and unambiguous authority to do it. That's really, really important work. It might be more important today than ever. So I just hope the court will consider that as it's making its decision as well. Thank you.
Thank you, Mr. Woods. Mr. Neppa, welcome back.
Hello again, Your Honors. Frank Neppa for the Commonwealth. Unless the court insists, I am going to decline to talk about the difference between thereby and which. If you think that thereby being used here decides the case, you have my blessing. You can.
Could you adjust the mic a little bit?
Yeah, sure. Is that better? Is that anyway? We're here to figure out what the legislature's intent was behind this statute and whether or not they intended there to be a separate sentence for each person placed in danger in this situation. And I think a very common sense way to look at it would be that the legislature likely would have thought that someone acting as Mr. Smith did, that is to say, someone who set a fire to a structure knowing that 4 policemen were in it, would be deserving of more punishment than someone who did that knowing that no one was in it or the one person was in it.
But would he be entitled or deserving of more punishment under this statute?
Well, in writing the statute, I'm saying you would think that would be their mindset. But Mr. Wood says that is not the way to look at this sort of thing anymore, and he might be right. I mean, the Frisbee court sort of did look at it that way. That was one of their rationales for the decision that they came to. But Mr. Wood says that's passé, and maybe that's right. But the more recent cases talk about determining what the way to determine what the legislature intended is to figure out what the unit of prosecution is for that statute. And he insists all along that it's the actus reus is the starting of the fire. But I just looked up what actus reus meant, and it means, literally, it means guilty act. And in the Black's Law dictionaries, they call it a forbidden act or a harmful deed or something to that effect. And if you just were supposed to look at the language of the statute, and the language of the statute says a person commits this offense if he intentionally starts a fire. Now that is not, as Justice Money pointed out, that in itself is not a guilty act. It's not a wrongful deed. It only becomes that after you read the rest of the statute.
Exactly. The issue is the criminal act of General Assembly, the public policy is, we will punish you for the act of intentionally starting a fire, and if that fire results in some reckless injury and or in an inhabited building, you're going to jail based upon these number of years, the gradation. The concept is then you have our case law with Sattersby and Frisbee indicating that Sattersfield says, no, it's the one unit of act, which is the fire. The subsequent injuries would lead to additional charges, AKA REAP, i.e. the Frisbee case, such that I, as the trial judge at sentencing, will sentence you to the max I can on the arson and consecutively sentence you on the lesser offenses that are, unless they're lesser included. Does that not make sense as to what the General Assembly was trying to accomplish? The criminal act of the intentional setting of a fire, but it must have one of 2 subcomponents, and that's it.
Yeah, I think if I'm understanding you correctly, I think I agree with you. But Mr. Woods seems to want you to stop reading after 15 words of the statute, and that is not what an actus reus is. In Satterfield, it's further defined as the minimum conduct that must be proven to obtain a conviction for the statute in question. The minimum conduct is not simply starting a fire. You can start a fire.
No, Mr. Woods' response to that is the minimum conduct is the starting the fire. That what makes it a crime punishable, what makes an otherwise innocent act punishable, is not an additional act on top of the innocent one. It's the result of the innocent act.
And
that's what Mr. Woods is. I mean, were you ever Boy Scout?
No.
Okay. I've sat around a few Boy Scout fires before. Boy Scouts love fire.
Yeah.
And they will put a lot of things in a fire to get that thing going.
Yeah.
And if I have Boy Scouts sitting around a fire and a Boy Scout throws something they probably shouldn't have thrown in the fire and the fire gets out of control, can that Boy Scout or Scoutmaster, I guess, be charged with this crime depending on the number of scouts that happen to be sitting around the scout fire.
If he intentionally started this fire with...
Well, I can see that scouts intentionally start fires. So I'm saying the scouts intentionally started the fire, and as a result of that fire that the scout intentionally started, several other scouts sitting around the scout fire were placed in danger.
Were they recklessly placed in danger? If they were, then I guess they would be.
And it depends on the number of scouts that are sitting around the fire, how many charges there would be.
In this
If
case,
there were 5 scouts sitting around the fire, there'd be 5 charges.
In this case,
Six,
we're
2.
talking just about sentencing, but yes, you would get multiple sentences, and you could,
By the same extension, here you have the 4 officers.
yeah.
So what if in the same structure there were 25 persons in
Yeah.
danger? 25 sentences?
Legally, I think you could get 25 sentences. Now, it's possible that if they were all consecutive, maybe that's excessive, and it would be an abuse of the court's discretion.
200 people, could be 200 sentences?
Yeah, legally, I think legally.
4 counts, right?
And here there were 4. There could have been more because
He pled guilty to 4.
he pled guilty to 4. He was only charged with 4. We could have charged more. We could have charged
But
the
I mean, he pled
firefighters.
guilty to 4, not 1. He pled guilty.
Oh, he pled guilty to 4. Yes. But I guess my point is, none of this, just the act of starting the fire cannot be an actus reus. It can't be. That's not what an actus reus is. And this court in Satterfield and in Davidson, I believe, talked about the unit of prosecution being the actus reus.
But we didn't look at it in the context of the entirety of a section that deals with a particular actus reus. I mean, we have an entire section, 3301, that deals with a variety of arsons.
Yeah.
Doesn't that make a difference?
Well-
And some of them are graded differently depending upon the and if that's included with the starting of a fire.
Well, I cited this in my brief somewhere. In conducting this sort of analysis, I think there's a statute to this effect, 1926 maybe or 1924. You're supposed to look narrowly at the statute, and the other sections and the other parts of this are not relevant. Now, the title becomes relevant, but only when there's an ambiguity to the statute, when you can't figure this out from the plain language. And the Commonwealth's position is there is no ambiguity here. If you look at the plain language, if the legislature had, instead of saying that a person commits this offense by starting a fire, if they had written, if a person commits this offense by intentionally and wrongfully starting a fire, maybe that's the actus reus. But when just starting a fire, they wrote something that in itself is an innocent act. And
Well, the act that gets the trigger is the recklessly placing.
yes,
You have 2 acts. You have starting a fire and recklessly placing.
yes, I get it. Yes, if the second thing is an act, yes.
Mr. Woods didn't address this, but I was really excited about the one point that he made about the Statutory Construction Act and the plural meaning the singular and the singular meaning the plural.
Yes.
Would you address that?
Well, I know that was mentioned in Frisbee, or Frisbee seemed to not think that they were bound by that, and they focused on the one person, or however they phrased it in that. Mr. Woods is saying that analysis is wrong. I don't know that it is, but if you look at that statute, I understand his point that statute seems to contradict what the court said in Frisbee about that particular
Can we
language.
say that too here, and recklessly places another person includes other persons?
Well, I mean, that's not the argument that the Commonwealth is making here. Again, the Commonwealth is making the argument that this beginning of this statute does not constitute the actus reus. And it has to be in conjunction with the rest of the statute.
Do you maintain that Judge Lazarus and Judge Pellegrini offered interpretations that are unreasonable?
Well, I know that Judge Lazarus said I have it written down here somewhere. She said the determining factor is not whether endangered person is a required element to convict a defendant, but whether it is the key element of the prosecution. That's what it is. We're saying that recklessly placing other people, another person in danger is the key element. And that's why I think she got that wrong.
Because, I mean, the reason I ask, and I'm sure you intuit this, is that if we conclude that we have competing reasonable interpretations of the statute, we're required to apply the rule of lenity, aren't we?
Yeah, I would agree. But the Commonwealth's position is not. It's not two competing versions of it or two competing interpretations. The Commonwealth's position is that it is not ambiguous. If you look at what this court has said previously about what constitutes a unit of prosecution, it's not ambiguous. That's the position taken by the Commonwealth. I mean, generally he's right if there were two competing interpretations, but we don't think that there are. Using the rules and using the case law that this court has put forth.
All right, any other questions for Mr. Nepa?
Thank you. Thank you very much.
Argued. Come back anytime. Mr. Minner, would you adjourn court?
We're adjourned.